All right, good morning, ladies and gentlemen. My name is Judge Law, and we're going to proceed with the Fulton State All-Purpose Calendar. These are a list of criminal misdemeanor cases in which the individuals have already been accused. Bonds were set, and today is tantamount to what we would consider a plea and arraignment calendar. If you are a defendant charged with one or more misdemeanor offenses, please remember that you have a right to remain silent about the facts of your case. Anything you choose to share with us during the course of this open court proceeding, your statements can and will be used against you. Please make a note that these proceedings are not only being done via Zoom, but they're also live streamed and recorded. If you also have a right to an attorney. If you cannot afford one, we have counsel from either the Public Defender's Office or the Conflict Defense List to represent you. I have Mr. McLean, who is in the courtroom with the Public Defender's Office. Ms. Catrice Helen, who's appearing via Zoom.
Good morning, Judge.
Good morning. I think we have one interpreter case as well. Ms. Lynn, good morning. Do you know which case you have?
Your Honor, I only have the case number. I don't have the name of the defendant, but I can give you the case number.
Okay.
It is 22 CR 006250G.
I believe that's going to be my case, Your Honor. Bernardo Ortiz.
Bernard Ortiz. Okay.
Ortiz Hernandez, Your Honor.
All right. As soon as the jail facility produces him, we will address the case. So
He's actually on bond, Your Honor.
repeat.
He's on bond.
He's been released on bond.
He has, Your Honor. Yes, ma'am.
Okay. So if that's is he appearing via Zoom?
He should be on the Zoom call, yes, Your Honor. I believe Adela Hernandez is probably one of his family members.
Do you want to sound up for him?
Is Bernardo Ortiz Hernandez present?
Bernardo Ortiz está presente. Bernardo Ortiz Hernández está presente en esta llamada de Zoom. Por favor, déjenos saber, active su micrófono. Buenos días. Señor Bernardo Ortiz Hernández.
All right, Mr. Bennett, why don't you go ahead and give him a call, because
Sure.
we do have an interpreter here who is ready to address this case, and I don't want her keep kept waiting any longer. Okay,
Yes, ma'am.
thank you.
Thank you.
Yes, Ms. Lynette?
Can we get that case number one more time? Because I don't see that case on our calendar.
22 CR 006250G. And April, if you can look at that and see why that case is on the calendar.
Thank you, Your Honor.
Mr. Bennett,
Yes, ma'am. I'm here.
okay, your client made bond, so that case is further notice for trial with the division judge. Yeah, so this calendar is mostly for individuals who have not made bond and are still at the Fulton County Jail. So unless you have any other matters to address, I can't address the case any further.
Very good. I appreciate you letting me know. And that concludes my business. I guess I'll excuse myself.
All right, thank you, Mr. Bennett.
Yes, ma'am.
Ms. Lee, if that was your only case, you're free to go.
Thank you, Your Honor. Have a good
All
day.
Thank you. All right, courtroom 2, who do we have, please?
We have position number 4, Mr. Malik Burnett.
Okay.
That is a non-negotiated plea of guilty, Your Honor.
All right. Can everyone hear Mr. McLean?
It's a little low, Judge.
Get this a little closer. Okay, is that
That's
better?
perfect. Thank you so much.
Okay, you'll need to speak up, Mr. McLean, just because of the logistical position of the monitor, okay?
Sure.
Okay, so position number 4, we have Malik Burnett, who is a case number 22 CR 006721G. Mr. Burnett, you're accused of fair evasion and willful obstruction of a law enforcement officer from October 6, 2022. This is going to be a non-negotiated plea. You've been advised of your right to remain silent, and your attorney is Mr. Mike McLean. Miss, is it Miss King?
Yes, good morning, Your Honor.
Good morning.
This-
What is the plea offer for Mr. Burnett?
It is 12 months to serve 28 days, credit for time served 14 days with the balance probated, a stay away from all MARTA, no further contact, and no drugs, alcohol, or weapons while on probation. The reason for this recommendation, Your Honor, is because he has a conviction just from June of this year for a criminal trespass that occurred at MARTA. Furthermore, he had another arrest from April of 2022 at MARTA, a criminal trespass and hindering persons making emergency telephone call that occurred at MARTA as well. This defendant was currently on a suspension at the time of the incident. It seems like every couple of months he's caught at MARTA again, which is why the state feels that the stay away from all MARTA is more than appropriate. Would Your Honor want me to go through the facts of the case?
Yeah, it's a non-negotiated plea. So you've already outlined the reasons why you want him on probation. It's just probation. He just has to be on reporting probation because of his numerous arrests in the past.
That's correct, Your Honor.
Okay.
So this-
I'm sorry, go ahead.
This offense occurred on October 6th, Your Honor, at the West End MARTA station located at 680 Lee Street Northwest. The plainclothes officers identified him getting into the station, pushing through the fare gate instead of paying. And so they went up to him to talk to him and to ask him why he was doing that. They also asked him for identification. He was not able to provide any. At that point, they went to detain him and he got away and started to run. Officers gave chase and ultimately he was able to get away. So that is the grounds for the obstruction charge and the fare evasion. The state is just concerned that he will continue to violate laws at MARTA and continue to be an issue. The state was extremely concerned with the hindering persons making emergency telephone call charge that he was charged with previously, because it's showing that he's even keeping people from calling law enforcement when he's breaking the law. And writing MARTA is a privilege, Your Honor. It's not a right. For that reason, we feel that the conditions stated are more than appropriate.
Mr. McLean, what is the issue with probation if I make it, if I waive probation fees?
Your Honor, waiving probation fees makes it entirely possible. He was concerned about the finances. He is from Philadelphia, and we had quite a good discussion about the differences of what the consequences of fare evasion. I think he has indicated that the stay away from all MARTA is something he will do, that he can do, and of course he can do it. But he understands this is the end of the line for this type of thing. The other things that the state mentioned, if he's not convicted of, I would, of course, mention that he is presumed innocent.
All right. I'm willing to allow for 6 months of probation reporting by Mr. Burnett. I will waive the probation fees for those 6 months. After 6 months, if there have been no problems, if there have no violations by Mr. Burnett, I'll make the probation non-reporting. Is that something that you and your client would like to consider?
I believe those features resolve his concerns. Would that be correct, Mr. Burnett? Do you understand?
We need to unmute courtroom two. Mr. Burnett, if you decide to accept this plea offer and plead guilty to fare evasion and obstruction, you will be placed on probation. The first 6 months of your probation, you must report every month. I will waive the probation fees. So that would be for October, November, December, January, February, March. Well, it will be actually end of April because we are almost through with October. At the end of April, if you've not violated any of the conditions of your sentence, including not being arrested again for anything, then your probation will be non-reporting. But you cannot afford to get arrested again while you are out on probation.
Understood.
Is that what you'd like to accept?
Yes.
All right. Raise the right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. And Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do so stipulate, yes.
Okay. Mr. Burnett, have you consumed any drugs or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
If you decide to plead guilty, you understand that you will have to waive your constitutional rights to a trial. You will not be able to go back to court to challenge these charges. You will not have the assistance of counsel to be able to question the state's evidence, to challenge the charges brought against you, to present your own defenses, confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
And are you satisfied with the representation of your attorney?
One more
Are
time.
you, are you satisfied with the representation of your attorney, Mr. Mike McLean?
Yes, ma'am.
Is anyone forcing you to take this plea today?
No, ma'am.
How do you plead to 1 count of fair evasion and 1 count of obstruction of an officer?
Guilty.
Your sentence is 12 months to serve 28 days, credit for time served 14 days. You will be on active probation from now until the end of April 2023. I will waive your probation fees from now until the end of April 2023. After April 2023, you will then be on non-reporting probation. At all times, while you're on active or non-reporting probation, you're to stay away from all MARTA property. You cannot go to any bus station. You cannot go to any train station. You cannot be in the parking lots. You cannot be in the sidewalks. And you're to have no further contact. Who's the no further contact
It's Officer Peters.
with MARTA?
Correct, Your Honor.
I'm going to amend that to no further violent contact with Officer Peters of the MARTA Police Department. And you're not to
Understood.
and you're not to consume any illegal drugs, no alcohol, and not possess any weapons. Do you have any questions about your sentence, Mr. Burnett?
No, ma'am.
You understand that you have to stay away from all MARTA property. If you return while you're on probation, you will be arrested, and you might end up serving the rest of the 12 months in jail.
Not being from Atlanta, how do I get a job here?
Well, that's going to be a problem. You'll need to learn how to bicycle or drive a car legally.
But I don't have any money to get a car or a bicycle.
I'm sorry, sir, you're going to have to figure out how to earn an income. Thank you.
You got it.
MARTA is a privilege, not an entitlement. Okay, I remember that. Okay, next case, please.
Next, we have position number 11, Mr. Damian Jenkins.
Your Honor, that is a negotiated plea.
All right. Mr. Damian Jenkins, your case is 22 CR 006-707E. You're accused of criminal trespass from October 4th, 2022. You've been advised of your right to remain silent. Your attorney is Mr. McLean. And may I place you under oath for purposes of this plea hearing?
Yes, ma'am.
Solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge.
Yes, ma'am.
Thank you. All right, Ms. King, this is a negotiated plea. What's the state's offer?
It is 12 months to serve 32 days, credit for time served 16 days with the balance probated, a stay away, no further contact, and no drugs, alcohol, or weapons. The stay away address is 1892 Howell Mill Road, and the no further contact is with ASADUZZAMAN, last name Mohammed, MOHAMMOD.
Azad. All right, I lost the spelling of the first name. I'm sorry.
ASADUZZAMAN.
All right. And Mr. Mohammed, right?
Correct,
Okay.
Your Honor.
Okay. And is 1892 Howell Mill Road a business or a residence?
It is a business, Your Honor. That is a gas station.
Gas station, okay. All right. Mr. McLean, these are the terms the state has offered. You've conferred with your client. Is he willing to accept these terms?
Yes, Your Honor, he is.
And you stipulate to the factual basis, venue, and ID?
Yes, we do so stipulate.
Thank you. Mr. Jenkins, I've placed you under oath. First of all, have you consumed any medication or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
Is anyone forcing you to take a plea today?
No, ma'am.
If you decide to accept this plea offer and plead guilty, you would have to give up your constitutional right to a trial. You will not be able to go back before a judge or a jury to question your witnesses, confront your accuser, challenge the state's case, and present your own defenses. The state will also not be required to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass?
Guilty, ma'am.
The sentence is 12 months to serve 32 days, credit for time served 16 days. Once you're released from Fulton County Jail, you must report to probation. Are there any holds on Mr. Jenkins? Mr. McLean?
It is my understanding he has 3 open cases, a shoplifting. It appears so because the shoplifting is from this month. So it appears he's out on bond for these.
Okay, well,
I
if
don't see-
you, I'm sorry, so he has no other holds other than these open cases?
Not from what I see, Your Honor.
Okay, so Mr. Jenkins, if you have no other cases holding you at the jail, and if you have been released on bond on the other matters, you need to report to probation next Thursday at JCS Pro. I'm so sorry, I just literally just blanked out on the address. I normally have it by road.
132 Mitchell Street.
132 Mitchell Street. Okay, it's all coming back now. Okay, thank you. You report to probation at 132 Mitchell Street in Atlanta, Georgia, next Thursday before 3 p.m. You will commence with probation, and if you, I'll waive your probation fees from now through the end of March 2023. After March 2023, if you have not been arrested and you're in compliance with all the conditions of your sentence, I will amend your probation to non-reporting. Do you understand?
Yes, ma'am.
So you report through March, and as long as you keep your record clean, then your probation will be non-reporting.
Yes, ma'am.
Okay, good luck, sir. Thank you.
Thank you.
Position 18 next.
Is that at the jail court's iPhone?
Yes.
Okay. Okay. Miss Helen, is that your client?
It is, Your Honor.
Okay. Are you Mr. Ryan Powers?
Yeah. Yes, Your Honor.
I'm sorry, the jail court's iPhone just went blank. Officer at jail, there we go. Mr. Powers, my name is Judge Lal. Can you see me on the screen? I'm waving my hand. You need to tell me whether you can see me.
I can see you.
All right. Can you hear me all right? All right, Miss Helen, I think the iPhone that's being used there may have a bandwidth problem.
Correct, Judge.
Okay. What are we doing with Mr. Powers?
Judge, this is a non-negotiated plea with the jail time at issue.
Well, we've lost him. So can we take the next case at the courtroom 2?
Understood, Judge.
We right here.
We don't see any video.
All right, it's under jail court iPhone, but there's no video. Deputy, I think there is a Wi-Fi issue with getting the video on your iPhone. All right, we're going to move on to courtroom 2 until the jail court iPhone with Mr. Powers has been corrected. Courtroom 2, who do we have? Courtroom 2.
We have, I'm sorry, Your Honor, I was up here talking, couldn't hear me. Position number 15, Mr. Ochoa.
Okay. This is Dio Vigildo Ochoa. I'm so sorry if I'm butchering your name, but
Yeah.
okay, Mr. Ochoa, your case number is 21 CR 007-7248, accused of battery, obstruction, and possession of use of drug-related objects from May 25th, 2020. With regards to your case, you've been advised of your right to remain silent, and your attorney is going to be Ms. Helen. This is position number 15, and we are doing a arraignment and a bond hearing. Is that still the terms?
That's correct, Judge.
All right, Mr. Ochoa, first of all, Ms. Helen, do you waive a reading of the accusation?
I do, Judge.
All right. Mr. Ochoa, you've been charged with this 3 misdemeanor charges: battery, obstruction of a law enforcement officer, and possession and use of drug-related objects allegedly occurring in Fulton County, Georgia on May 25th, 2020. You do, as already explained, you do have a right to remain silent, and you do have a right to an attorney, and these rights will prevail throughout this case and throughout your trial as well. While you are charged with these offenses, upon your entry of a not guilty plea to these charges, the case will then be scheduled for trial. At the time of the trial, you'll be represented by counsel, and the prosecutor would have the complete burden to prove all 3 charges against you beyond a reasonable doubt. If the prosecution does prevail and you're convicted of 1 or more of these charges, you could possibly face a sentence of up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how do you plead?
Guilty?
Not guilty.
I'm sorry, Mr. Ochoa,
Not guilty.
you've already spoken to your attorney. Do you recall speaking with your attorney?
Yeah, but I think we had agreed on that, so we.
And what have you agreed to plead?
Signature bond?
Do you want a trial in this case?
Yeah.
All right.
Mr.
you-
Ochoa, when I went and spoke to you, you wanted me to have a bond hearing so that I can request a bond modification. Is that still the case?
Yeah, that's the case.
Oh, okay.
So are you pleading not guilty and want to have a trial?
Yeah.
This case is arraigned and further notice for a trial. Tell me about the bond modification request, Ms. Helen.
Yes, Judge. Mr. Ochoa is 35 years old. Yes, he's from California, but he's been in Georgia the last 8 years. I do believe he's a resident in the Marietta area. His mom and dad are also living in the Marietta area. At this time, Judge, he's employable because he was working with a construction company doing sealing and stripping for the last 3 years. I do believe he has 2 children, one 9-year-old, one 11-year-old that are also living in Marietta, Judge. So we are asking for a bond modification, no more than a $1,500 signature bond, a $1,000 for the battery, $250 for the obstruction, and $250 for the possession of drug-related objects, Judge. When I went to and spoke to Mr. Ochoa, he's going to come to all of his court dates, Judge, but we are petitioning the court for that signature bond modification this morning.
Okay. So he has an open felony case as well,
That's correct, Judge.
and that's from April 3rd, 2022. And his arrest warrant was issued on April 13. Okay, Ms. Saleh?
Your Honor, the state would request that the current bond amounts stay in place. But if Your Honor is looking to lower the bond amounts, the state would ask for a minimum of $1,000 per charge, surety bond on each charge. This incident happened back in May of 2020, May 25th, 2020, at 215 Northwood Drive in Sandy Springs. Officers were called out and they observed that the victim in this case, Roller Guzman, ROLLERGUZMAN, was being held up by a bystander. They spoke with the Maria Guzman, who was on the scene, who saw the incident occurred. And they said that the defendant came up behind Mr. Guzman and hit him in the back of the head with a closed fist. Mr. Guzman at the time couldn't remember the year, the president, his address or phone number. And he did have to be taken to get medical treatment. Upon officers' arrival, the suspect was not on the scene, but they said, a bystander said that that the defendant had ran away. Upon searching the area for about 10 minutes, they were able to come across the suspect, and he continued to try to flee away from officers, and they were finally able to arrest him at 5675 Roswell Road. The state would also ask that there be no contact with Roller Guzman and Maria Guzman. Stay away from the 215 Northwood Drive location. No alcohol, drugs, or weapons while out on bond, and a one-day anger awareness.
Okay. Response, Ms. Ellen?
Yes, Judge. I don't believe Mr. Ochoa knows either Roller Guzman or Maria Guzman at all, Judge. And so we agree with the stay away. We agree with the no contact, Judge. But today we're asking for that bond modification in the amount of $1,500 signature bond. Again, Judge, he's the only person bonding himself out. He's not going to be able to afford even a $3,000 surety, Judge. So we are asking for that bond modification, if not the signature, in the form of a surety bond of the same amount of $1,500, Judge.
On the
And-
battery, I'm sorry, on the battery is 1,000?
Your Honor, I'm sorry. I just wanted to add in his history. If I may, I don't think.
You may, it's going to be a surety bonds, and you've requested $1,000 in each count. So do you have anything else to add?
I'll just add for the record, he has 14 arrests, 2012 simple battery conviction, 2021 disorderly conduct obstruction conviction, and a 2014 FTA arrest. So the state would argue that he poses a risk of not appearing for court and reoffending while out on bond.
Yeah, that's why I'm going with the surety bond. He doesn't qualify for a signature bond based on his criminal history record, based on his failure to appear in court on 2 prior events, and based on the fact that he has an open felony case from just this year alone. So on the battery is 1,000. On the obstruction is going to be 500, and these are surety bonds. On the possession and use of drug-related object, that's going to be a 500 signature bond through the jail. So total of $2,000. It's a split bond. No further contact with Roger, RODGER, Roger, Roller, and Maria Guzman. No alcohol, no illegal drugs, no weapons, and no firearms. And he must update the court with any address changes that he has as soon as possible, and show up for court when next summoned. This case is further notice for trial.
And Judge, I apologize. Is there a stay away from that 215 Northwood Drive?
I didn't see that. Was there a stay away requested? Is that a residence 215?
That's a shopping plaza, Your Honor, but I think there's a bunch of different locations. I think they were at a bar at that location.
I'm just doing the no further contact.
Understood, Judge.
All right, please send the proposed bond modification order to Ms. April Champion. Thank you.
Thank you, Judge.
All right, I'm going courtroom 2. Yeah, I'm going to 4 North, and who do we have there? Position 8, and that's Mr.
Your Honor,
McClain.
can you finish doing jail court's iPhone? He's in a lockdown zone.
Okay, I understand.
Can
Can you? Okay, 4 North, please hold. Jail court iPhone. Okay, you moved to a different screen. There you are. Okay, got it. And remind me again, what position number was it? Brian Powers, 18, okay. Mr. Powers, you have a right to remain silent. Anything you say about the facts of your case, the statements can and will be used against you. You have a right to an attorney, and representing you is Miss Helen. This is case 22 CR 006282 F. Mr. Powers is charged with battery. This is a non-negotiated plea. Miss Salette, what's the plea offer, please? 12 months to serve?
Yes, Your Honor.
Right.
The basis for that recommendation, on September 16th, 2022, Officer Lassane with the Atlanta Police Department was flagged down by a witness, Stephen Kraus, who stated that at 1820 Peachtree Street, he witnessed a male, the defendant, walk up to the victim and strike her in the back of the head with a closed fist and then proceeded to walk away. The Officer Lassane was able to observe video footage of the incident that was taken from a nearby store at that incident location. The victim's name is Melissa Rainey, and she does not know the defendant at all. It was a random attack. The defendant's history, he does have a prior 2022 simple battery in July of this year, where he did a similar attack on two people that were strangers to him, where he randomly hit both of them in the back of the head and tried to flee, but the male victim was able to hold him down until an officer arrived on the scene. We do have that video footage, Your Honor, and the state would like to share it for Your Honor to see how egregious the attack was.
Any objection, Ms. Helen?
Yes, Judge, I haven't had the opportunity to review that video with my client for this video to be held against Mr. Powers. I'd like an opportunity to reset it and show Mr. Powers that video, go over that information with him. I haven't had the opportunity to do that, Judge. So yes, I do object.
I'm going to allow, objection overruled. I'm going to allow for the video, and then we'll see whether you want to still accept this plea offer or reset it. Ms. Salette, you may screen share. Ms. Champion? Oh, Ms. Salette, I think her Wi-Fi is suspended.
Yes, she appears to be frozen, Your Honor.
Has she left the Zoom?
She may be trying to get back in, restart and jump right back in. I'll reach out to her now.
Okay. While we're waiting, I have 4 North. Who do we have at 4 North?
Position 20, Shelton.
Okay.
That is Attorney Salette's position as well. I'm positions 1 through 14, and I can handle those until she gets back.
Position 20 is just an arraignment. Would you be able to handle that, Ms. King?
Yes, Your Honor.
Okay. Mr. Stephen Lamont Shelton, can you see and hear me?
Yes, ma'am.
Okay. Mr. Shelton, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Catrice Helen. This is going to be an arraignment of your case 22 CR 006-872H, in which you are accused of simple battery against a public school system employee, allegedly on May 20th, 2022 in Fulton County, Georgia. An arraignment simply means I'll explain the terms before you enter a not guilty plea. And Ms. Shelton, do you waive a reading of the accusation?
Yes, ma'am.
Okay.
I do, Judge.
All right, thank you. Mr. Shelton, I've already described the misdemeanor offense brought against you. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the state would have the complete burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the state prevails, you could be convicted and face a penalty of up to 1 year in jail and or up to $1,000 fine. Given this information, how do you plead?
Your Honor, I would like to plead not guilty, and Judge Wolf never signed that warrant.
Just 1 second. This is Stephen Shelton Lamont, okay. All right, I see the warrant for the other case. This is the warrant for the other case, and Miss Helen, you know what I'm referencing?
Yes, Judge, when I tried to look up particular case, I couldn't find it. I couldn't find that it was holding him at all. According to
Oh,
Mr.
that other case is definitely holding him. He's got no bond.
The simple battery against the public school system employee,
That one, I don't know whether it was a, hang on, let me see.
and that's what
He's being held on an aggravated stalking.
Right. I just don't see the warrant. There's no documents on the simple battery. Okay. Anything else then? I don't
no,
see,
Judge.
I don't even see a bond. I just see the charge. It's an accusation. It's not a warrant-based case.
Correct, Judge. And when I spoke to him, the Judge Wolf, according Wolf, W-O-L-F-E, did
Yeah,
not.
I
sign the
know,
warrant.
Judge Bobby Wolf, yeah. There's no warrant for this particular charge. It's an accusation, but there is a warrant for the aggravated stalking. So and it's a case, a felony case with no bond. So,
Understood.
so the bond in this case, I'm going to set it at a $5,000 signature bond through the jail.
Understood, Judge.
And since there's no warrant in this particular case, it has to be restriction free, but he's got the aggravated stalking, so he's got another fire to put out.
Understood, Judge. And I'll get that form to Miss Champion.
All right, and please send the bond order to April 10th. Thank you. Oh, you just said that. Sorry, my brain's already on a train just going one way. Okay. All right. Anything else with Mr. Lamont?
No,
Mr.
Judge.
Shelton? All right.
Nothing from the state.
Okay, thank you. Miss Salette? No? Yes?
Yes, Your Honor, I'm sorry.
Oh, there you go too. Okay, let's see your video. If you shut your video, sometimes that is less burden on your bandwidth if you want to screen share the video. That's up to you. But we are ready for the video.
I think that I have to get,
Miss Grace, can you give Miss Salette permission to share screen?
Yes.
Thank you. All right, do you have it, Miss Salette?
yes, can you all see it?
No, you have to start the video and then share screen and then click on the video.
Okay.
You need to open the video in a separate window. There we go. All right, now you can, okay, you can go ahead and play the video. Thank you.
Thank you, Judge.
And what are we looking at?
This is the defendant here, kind of walking in the middle of the screen, and the victim is over here on the left side of the screen.
Okay, is that the Melissa Rainey?
Yes.
Okay. All right, thank you.
Thank you.
And you can cancel your screen share. Okay. All right. Miss Helen, Okay, anything else, Ms. Salette, with regards to your plea offer on this non-negotiated plea hearing?
Your Honor, the state is strongly recommending the 12 months to serve, but if you are not inclined to grant our recommendation, then the state would ask, I think that there could possibly be some MH issues here with his last case that he pled guilty to, the simple battery with a similar fact pattern. There was some, I guess, allusion to that in that police report. The state would ask that he be released to some sort of inpatient facility if the defense is able to facilitate that in some sort of way. I don't know, but I do think that there needs to be some sort of treatment in regards to his sentencing. And so I'll just leave that for Your Honor to consider.
All right, thank you. Ms. Helen,
Yes,
why
Your-
should I not consider 12 months to serve?
Because, Your Honor, I'd like to ask for a recommendation for MHET. If we can be given a time maybe to reset this case, I can contact the facility that we can arrange transfer from the Fulton County Jail right into this program for Mr. Powers. So Judge, we are asking that the 34 days that he's done be time served, but we would like to potentially reset this so we could get a location and a program to release Mr. Powers from the jail directly into that program with a MHET added to the recommendation, Judge.
All right. Typically, when I'm given two alternative plea offers, and given the evidence that was presented, as well as the fact that Mr. Powers just pled guilty to 2 counts of simple battery back in July of 2022, I'm exercising my judicial discretion and denying this plea. Mr. Powers will remain at the Fulton County Jail on the bond that he presently has, which is $1,500 surety bond. No further contact with Melissa Rainey. And Ms. Powers, we can reset this case 2 weeks out. If you decide that you would like to get Mr. Powers evaluated and perhaps replaced on the competency calendar, I will let you decide that within the next 2 weeks. So this case is reset to November 3rd? Okay,
Understood, Judge.
thank you. Jail court, we are concluded with Mr. Powers. He has got a $1,500 bond. His plea offer is denied, and we will see him on November 3rd. Thank you.
Thank you, Judge.
All right, moving on to courtroom 2. Who do we have?
We have position 22, 23, and position 24, Mr. Teague.
And he's correct, Judge. That is 22 through positions 24.
Ms. Helen, do you waive a reading of the accusations in these 4 cases? Three cases, excuse me.
Correct, Judge, I do.
22. Mr. Teague, Quatarius Teague, my name is Judge Lal, and we are addressing 3 separate cases in your regard. The first one is 22 CR 006702G, in which you are accused of theft by shoplifting from July 19th, 2022. And the second case, 22 CR 006703G, you are accused of theft by shoplifting and misdemeanor terroristic threats and acts from August 2nd, 2022. In your third case, you are accused of simple battery and theft by taking in case number 22 CR 006705G from May 18, 2022. With regards to all 3 cases, you have been advised of your right to remain silent. Your attorney is Ms. Patrice Helen. Ms. Helen has waived a reading of the accusations in all 3 cases. What I do want to inform you is that this is an arraignment. In other words, upon your entry of a not guilty plea to these 3 cases, I will let you know what's going to happen in the course of having a trial. You are charged with these misdemeanor offenses that I've listed. They all allegedly occurred in Fulton County, Georgia. Upon your entry of a not guilty plea to the charges listed in 3 cases, your cases will then be scheduled for trial. At the time of the trial, whether it's before a judge or whether it's before a jury, you will have the assistance of counsel. That trial will require the prosecutor, only the prosecutor, the state, to have the complete burden to prove the charges against you beyond a reasonable doubt. If the state does succeed and prevail, you could be convicted of 1 or more of these charges in these 3 cases, and you could face a penalty of up to a year in prison and or up to $1,000 fine for each convicted offense. All right. Given this information, how do you plead to the 3 cases I have just outlined?
Plead guilty.
Mr. Teague, when I went and spoke to you, you said you wanted to have a bond hearing for all 3 of your cases, correct? And you wanted me to ask the judge for a bond modification, correct?
Yes, ma'am.
Oh, okay.
So if you are just asking for a bond modification, but if you want a trial, then your plea would be not guilty. If you're pleading guilty, then I'll be sentencing you to up to 12 months to serve unless I hear something different.
I plead not guilty, man. I misconstrued what I had somebody in the back talking. I couldn't right hear you, ma'am.
Let me repeat what I just said. Given the information I've provided you with all 3 cases and that the state has the complete burden to prove the charges against you beyond a reasonable doubt, how do you plead?
Not guilty.
All right, all 3 cases are arraigned. And before we proceed, is it Miss Harrison or who is up? Yeah, Miss Harrison, good morning.
Good morning, Judge.
Right. We are addressing Mr. Quaterius Teague, positions 22, 23, and 24. He's got these 3 open cases in 2022. What's his GCIC, please?
He has 14 cycles. Last arrest, January of 2011 for theft by receiving stolen property, fleeing or attempting to elude, driving without a valid license, willful obstruction of law enforcement officers, giving false name, possession of marijuana less than an ounce, armed robbery, aggravated assault, criminal damage to property, 2nd degree. It indicates and open that case is open, but I'm not sure. Let me, one moment. It was a conviction, Judge. He was convicted of the armed robbery, criminal damage to property, possession of firearm during the commission of a felony, 2 counts.
Okay.
Under case 11 SC 98571.
All right. Okay, 1, 2, okay. And Miss Helen, what's the reason for a bond modification? He's got a $7,000 bond at present?
Correct, Judge. I see, yes, Judge, I see the $1,000 for the theft by shoplifting. We're asking for a bond modification of the same amount to a signature bond. When I spoke to Mr. Teague, he was unstable financially as well as residentially when the theft by shopliftings happened, Judge. I have a more stable contact information from his mom. Also, he has he's employable. He did have some type of application for the railroad industry. Working with that company, Judge. And then also, we're also asking for a signature bond in the 2nd case, the theft by shoplifting, in the same amount, Judge. The 3rd case is allegedly a theft by taking and a simple battery. The reason why we're asking for a bond modification of the same amount, Judge, I do believe that may be with the Miss Gates, and I believe she may be on a Zoom call, Judge. When I spoke to Mr. Teague, he is a proud father, I believe, of 2 children currently and 1 on the way, Judge. And so we are asking that he be allowed to fight these cases on the outside. He wants to take all 3 to a jury trial, Judge. And we understand if he does not qualify for the signature bond, but Judge, we are asking for that bond modification to a signature bond of the same amount. And he's also a lifetime resident of Fulton County. I don't believe he's going to miss any court dates. He understands how serious all 3 of these cases are, Judge.
Yes, all from this year alone. All right, Ms. Saleh?
Yes, Your Honor. The state would just argue that the defendant was given a reasonable bond on October 6th. We haven't heard anything today that wasn't heard on October 6th. I don't think that there's a reason for a modification at this time. As you stated, all 3 of these cases happened in a span of 3 months. And if he wants a trial, then he can have a jail jury trial. So the state would ask that the reasonable bonds that were in place on October 6th remain, Your Honor.
So Ms. Helen, you said he's employable. What was he doing this year? What was his employment history this year?
Well, Judge, this year he applied. So he had a history with working and applying with the railroad industry, laying down track for that industry, Judge. So he is employable. I do have that he's been incarcerated for the last 15 days. So Judge, again, he's not able to make those bonds as set, and we are asking for the bond modifications today.
He's got other foreign holds as well in Douglas County, and I'm not sure where else. And from what I understand, he pled guilty to, or he pled in the other case from 2011. It's tough, Miss Helen. He's got a significant pattern that doesn't qualify him for a signature bond. I'm looking at the pattern of these 3 cases: May 18, August 2nd. No, excuse me, May 18th, July 19th, and then August 2nd. It is way too repetitive to qualify him for a signature bond. I will amend all the charges to $1,000. Position 24, I'll amend that to 1,000 each.
And what
Same
type of bond, Judge?
conditions, all surety.
Understood.
In May, in July, and then in August, Mr. Teague has shown a pattern of a very high likelihood to reoffend. So he doesn't qualify for a signature bond, but I will modify them all to they're all $1,000 each, which is reflective of not only his criminal history record, but his repetitive pattern of reoffending. Thank you.
Understood, Judge.
Same conditions apply. All 3 cases are further notice for trial. Thank you. Next case, please. Courtroom 2.
Excuse me, so, man, what do it mean, do I get a signature bond?
You don't qualify for a signature bond. I've already explained it, that you demonstrate a high likelihood to reoffend.
So I'm kind of lost, so what it mean, like, can you explain a little more?
Well, Judge, I'll give him a call. Mr. Teague, I'll give you a call.
Give him a call?
Yeah, right there at the courtroom too. I'll give you a call.
All right.
Thank you. Next case, please.
Next, we have Nicholas Taylor, position 21.
That's my position as well, Judge. Would you like me to take that and then give Mr. Teague a call?
Yes, please. And was that 20, what was that 21?
That is correct, Your Honor, 21.
Thank you. This is Nicholas Robert Taylor, accused of loitering and prowling, criminal trespass, and willful obstruction of an officer from October 4th, 2022. This is going to be a non-negotiated plea. Mr. Taylor, you've been advised of your right to remain silent, and your attorney is Ms. Catrice Helen.
And Judge, I don't want to interrupt you. The only reason it's non-negotiated, I just wanted to ask if the state is willing to terminate once he's completed the conditions of the $300 fine. Otherwise, Mr. Taylor agrees with everything else. We are just asking the state if they'd be amenable to terminating once he completes the condition.
All right.
I have an objection to that.
Ms. Salette, was that a yay or nay?
That's a yay. We can do a negotiated plea, Your Honor.
Okay, thank you. All right. So, Mr. Taylor, it appears that the state will provide you with a plea offer that is acceptable to you and your attorney. So may I place you under oath?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
All right, let's listen very carefully to what the prosecutor is saying. Ms. Taylor, Ms. Taylor Salette, we are all ears.
No.
Yes, Your Honor. For the criminal trespass charge, the state is recommending, for loitering and prowling, time served, I believe it's 15 days. For criminal trespass, 12 months served, 15 days, credit for time served, 15 days, balance suspended, and a stay away from the incident location, which is 5457 Roswell Road, Sandy Springs. And it's a business, FMLS, on the willful obstruction of law enforcement officer. The state is recommending 12 months served, 15 days, credit for time served, 15 days, balance probated, a $300 fine or 30 hours community service. And that probation can terminate upon completion of the fine or the community service. The state also added a giving false information to a law enforcement officer charge, and the state's recommendation is time served. All of that is to run concurrent, Your Honor.
All right, Ms. Helen, those are the terms. There appears that if he completes, he will be reporting to probation until he pays off the $300 fine, or he does 30 hours of community service. Which option has your client selected?
$300 fine, Judge.
Okay, so once he pays off the $300 fine while he's on probation, the probation will go did we agree to termination?
Correct, Judge.
All right, then we will terminate probation. I will waive his probation fees through the end of this year, which would be October, November, and December, for him to pay his fine. If he pays it by the end of the year, his probation terminates. Otherwise, January 1st, 2023, while he is paying his fine, he would also have to start paying probation fees. Mr. Taylor, do you understand?
Yes, ma'am.
All right. Ms. Helen, do you stipulate to the factual basis, venue, and ID?
I do, Judge.
Thank you. Mr. Taylor, may I please, I can't remember what, yeah, I did place you under oath. Okay. Do you do you understand what's been going on so far?
Yeah, I totally understand.
Okay, you've not consumed any medication or alcohol recently, right?
No.
And are you satisfied with your attorney?
Yeah, it's a good call.
All right, and have she gone over all the waiver of rights that you would have to sign off on if you decide to take this plea offer?
Yeah, I'm fine with that.
So you understand that if pleading guilty to these charges, you would have to waive your right to have a trial, to confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Do you understand that?
That's fine. Also, is there a way to get all these charges off my record?
That is something that you can discuss with your attorney on how to have your record restricted.
That's awesome. Thank you.
All right. But in the meantime, is anyone forcing you to take this plea offer?
No.
And how do you plead? To one count of loitering and prowling, first criminal trespass, willful obstruction of a law enforcement officer, and the fourth additional charge of giving false information to an officer.
Guilty.
Your sentence on the loitering and prowling and the giving false information is time served. In other words, if you've been serving 15 days, you'll be given full credit for that time, and your time on those two charges is concluded. On the criminal trespass charge, your sentence is 12 months to serve 30 days, credit for time served 15 days. Your time on that charge is concluded. Do you understand?
Yes, ma'am.
And the balance is suspended, but you cannot return to the business listed as FMLS at 5457 Roswell Road in Sandy Springs. If you are seen anywhere near that property, like within 200 yards, which is the length of 2 football fields, they can call the police and have you arrested again. This is your notice that you cannot return to that location. Do you understand?
Yes, ma'am.
Okay. On the willful obstruction, your charge is 12 months to serve 30 days, credit for time served 15 days. Your jail time on that charge is concluded. You will report to probation next Thursday at 132 Mitchell Street in downtown Atlanta. 132 Mitchell Street in downtown Atlanta. You'll be placed on probation. They will create a probation file. I will waive your probation fees from now through the end of the year for you to pay your $300 fine. You will make those payments directly to your probation officer. Understood?
Yes, ma'am.
If you pay everything off by the end of the year, your probation's terminated. If you still haven't paid off your fine, you will continue to report to probation and start paying probation fees as well, beginning January 1st, 2023.
Okay, yes, ma'am.
All right, that concludes your case.
Thank you, Judge.
Next, we have position number 19, Mr. Robinson.
Is that
And
still
Judge-
Ms. Helen?
Yeah, Judge, this is only non-negotiated. We're asking that he be allowed to use the MARTA just in adherence to any suspensions that are present. Not necessarily a stay away from all MARTA.
So stay away from MARTA in accordance with any active suspensions.
Correct, Judge.
Any objection, Ms. Salet?
Objection, Your Honor.
All right. Do we know if there are any active suspensions?
I do believe there is to the end of November, if I can be corrected, but I do believe that there is.
That's correct.
Okay,
End of November 2022, correct?
Yes, Your Honor.
All right, so I think, okay. So we are addressing, so are we still going to deem this to be now a negotiated plea?
correct, Judge.
All right.
Yes,
This is Shaquille Robinson, accused in 22 CR 006-729J, accused of fare evasion and criminal trespass at MARTA property from October 6, 2022. Mr. Robinson, you've been advised of your right to remain silent, and your attorney is Ms. Helen. May I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Robinson, I'm going to hear the plea offered, then I'm going to hear from your attorney. Ms. Salet?
Yes, Your Honor. For position 1, the fare evasion, it's going to be a time served recommendation for 15 days. For the criminal trespass charge, the recommendation is 12 months served, 15 days, credit for time served, 15 days, balance suspended. And I guess it would be that stay away from MARTA in accordance with any suspension that's currently in place by MARTA.
Okay, understood. Thank you. Ms. Robinson, I'm sorry, Ms. Helen, do you stipulate to the factual basis, venue, and ID in this case?
I do, Judge.
All right, thank you. Mr. Robinson, you've been sworn. Have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take a plea today?
No, ma'am.
If you decide to plead guilty to fare evasion and criminal trespass, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not be able to confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charges against you beyond a reasonable doubt. Have those rights been explained to you?
Yes, ma'am.
And are you waiving those rights?
Yes, ma'am.
How do you plead to 1 count of fare evasion and 1 count of criminal trespass?
Not guilty.
Not guilty, so we want a trial?
Yes, ma'am.
All right, Ms. Helen, appears your client now wants to have the case arraigned.
Mr. Robinson, are you accepting the plea of guilty? Then you're telling the judge, yes, I plead guilty.
I would, yeah, I think I would shit, cause charges up here, I know that we talked about, I was gonna plead not guilty, but I feel like I should just plead guilty because I was wrong for
No, Mr. Robinson, you told me you wanted to accept the plea and plead guilty. So are you understanding? Do you need me to give you a call?
No, ma'am. I want to plead guilty.
Right, that's what I announced to the judge. Did you think I announced something different?
No.
Okay.
All right, let me repeat again. Mr. Robinson, if you decide to plead guilty to these charges, you will have to waive your rights to have a trial.
Right.
You will be sentenced today and you'll be required to stay away from all MARTA property in accordance with any active suspensions. Right now, we know of one active suspension, which is through the end of November 2022, which means that most likely you can go back to using MARTA on December 1st of this year, not any sooner. Do you understand?
Yes, ma'am.
So in addition to pleading guilty, you will not have a trial. You will not go into a courtroom, have the assistance of an attorney to examine and cross-examine witnesses, challenge the state's evidence, confront your accuser, and have the state try to prove the charges against you beyond a reasonable doubt. These are all rights you have to waive. Are you prepared to waive them?
Yes, ma'am.
How do you plead to one count of fair evasion and one count of criminal trespass?
Guilty.
Your sentence on the fair evasion is time served. On the criminal trespass is 12 months to serve 30 days, credit for time served, 15 days. Your jail time is concluded. The remainder is suspended. If you have no other holds at the jail, you should be released, but you cannot use MARTA until you confirm that you have no active suspensions against you. Understood?
Yes, ma'am.
Thank you.
Thank you, Judge.
All right, do we have a case for Mr. McLean?
For South, positions 1 and 2, Mr. Berry.
For South, there we are. And what position number again, please?
1 and 2.
1 and 2, okay. Mr. McLean, we ready?
Your Honor, Mr. Mario Berry pleads not guilty. These are not on his booking sheet. Bond is moot.
I have 3 cases, 1, 2, and 3. Is that correct?
No, Mario Berry is one person on 1 and 2, and he is a separate person from Ricky Berry, number 3.
Okay.
They're not related as far as we know.
Well, it's just a bizarre coincidence. I've never had 3 Berries all in the same. Okay.
Well, Chuck is entirely missing.
Okay. All right. Mario Berry has 2 cases before the court, 22 CR 001314Y, charged with battery, domestic violence from October 20th, 2021. Mr. Berry also has a second case, 22 CR 001315Y, also accused of battery, domestic violence from December 1st, 2021. Mr. Berry, my name is Judge Lal. I'd like you to remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean. Understand that you will be entering a not guilty plea, so I will arraign your case. Do you waive a reading of the accusations, Mr. McLean?
We waive the reading, Your Honor, if you would just simply arraign him.
All right, thank you. Mr. Berry, upon your, I've already listed the 2 charges that have been brought against you. They appear to have occurred in 2021, allegedly in Fulton County, Georgia. Upon your entry of a not guilty plea, these cases will then be scheduled for trial. At the time of the trial, you will have the assistance of counsel, and the attorneys for the state, the prosecutor, would have the complete burden to prove the charges against you beyond a reasonable doubt. If the state prevails, you could be convicted and face a penalty of up to $1,000 fine and or up to a year in prison for each convicted offense. Given this information, how do you plead to the 2 cases I have listed?
Not guilty, Your Honor.
You have been arraigned and further notice for trial. That concludes these cases. Thank you. Moving back to courtroom 2, who do we have, please? Officer Francois, Officer Norris.
I'm sorry, Your Honor. We got, Mr. Davis. I don't know the position number.
It's position 5, I think. Emmanuel Davis, are you
That's
Mr.
correct.
Emmanuel?
Yes, ma'am.
Okay. And this is Mr. McLean's case. Miss Helen, I hope you're on the call with the jail right now. Okay. Mr. Emmanuel Davis is 16 CR 004469H for an incident occurring on December 27, 2014. It appears to be a traffic matter in which he was accused of driving while license suspended or revoked, reckless driving, having defective or no proper headlights, and speeding. Mr. Davis, these were the 4 charges brought against you. You've been advised of your right to remain silent, and your attorney is Mr. McLean. This is going to be a negotiated plea. So, Mr. Davis, may I place you under oath?
Yes.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. King, what are the recommendations for Mr. Davis?
It's 12 months to serve 22 days, credit for time served 11 days with the balance suspended.
Concurrent for all charges?
Yes, Your Honor.
Thank you. Mr. McLean, do you waive a reading of the, do you stipulate to the factual basis, venue, and ID for these 4 charges?
Yes, Your Honor, we do so stipulate.
All right, thank you. Mr. Davis, have you consumed, I'm sorry, I'm going to wait for it to unmute. Thank you, Mr. Davis. There we go. All right. Mr. Davis, have you consumed any medication or alcohol recently?
No, ma'am.
And are you satisfied with the representation you received from Mr. McLean?
Yes, ma'am.
Is anyone forcing you to take a plea today?
No, ma'am.
All right. I think the phone conversation just needs to chime down a little bit. Sorry. Tell me if you can hear me, okay?
I can hear you though.
Okay, excellent. And have you understood the proceedings so far?
Yes, ma'am.
If you decide to plead guilty to these charges, you would have to be sure that you are waiving your right to a trial before a judge or a jury. You will also have to waive your right to have the assistance of counsel so that you could challenge the state's evidence, present your own defenses, question witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am. I understand.
Mr. McLean, you have explained to him that by pleading guilty, this will automatically suspend any license he has presently.
Yes, Your Honor.
All right. Mr. Davis, do you understand that?
Yes, ma'am.
Okay. How do you plead to 1 count of driving while license suspended or revoked, reckless driving, driving with no proper headlights, and speeding?
Your Honor, if I may, before he takes the plea, it was the state's intention for the speeding to merge with the reckless driving. If Your Honor would please notate that on the paperwork. My apologies for interrupting.
But that's good. That's a good thing.
All right, April, can we modify the disposition? Thank you. I'm sorry, Mr. Davis. I just wanted to pause at this point. Based on what the prosecutor told me, you are pleading guilty to driving while license suspended or revoked, reckless driving, and driving with no proper headlights. The speeding charge is merged, so you'll only be pleading guilty to 3 charges.
So what would that leave the speeding charge?
The speeding charge merges, that means it doesn't exist anymore.
Okay.
The sentence is still going to be same. So do
Okay.
you understand? It'll just be the 3 charges, not 4.
Yes, ma'am. I understand.
Okay, thank you. So given the information that I've provided, how do you plead to the 3 charges?
I plead guilty, Your Honor.
Repeat,
Guilty.
your sentence is 12 months to serve 22 days, credit for time served 11 days, balance suspended. That means your sentence for these 3 charges are completed. If you have no other cases holding you at the jail, then your case is closed, you're done.
Thank you, Your Honor.
All right. Be mindful that your license will be automatically suspended, so do not operate a motor vehicle unless you have a valid current license, proper insurance, and proper registration.
Yes, ma'am, I
I
understand.
do not want to see you in traffic court, let's put it that way.
Yeah, yeah.
Thank you.
Thank you.
Your Honor, I only have one competency, person in here, but I don't see, Mr. Howard on.
Oh,
I have,
Mr. Walker or Mr. Howard? Either one present?
I can
Okay.
text Mr. Howard. But officer, do you have Mr. Daryl Paris? Is he coming?
no, I don't have, he's upstairs.
Okay.
All right, so I don't see any other cases showing up for SAP. I had a couple of add-ons also, Densillary sheets. Officer Norris, do we have oh, I see, Officer Milton, do you have a Densillary sheets? No.
No, I have Miss Hill,
Okay,
Shaquila Hill. I have to go get her, but I was told that she has a private attorney. So that's why I'm checking to see before I bring her around.
Miss Helen or Mr. McLean, do you represent position 8, Shaquila Renee Hill?
Mr. Samuel Rail, R-A-E-L, is on the Zoom call, Your Honor. He
Yes,
represents-
I'm here, Your Honor. I'm trying to
Okay.
get my video working, because
All right.
the host has disabled it.
Oh, okay,
You're
what you
right,
need to
but
do,
she has
Mr.
a-
Rail, is leave the Zoom and come back in and make sure that your video and your audio are both connected.
Your Honor,
Uh,
the state has an announcement in that case, that may save Attorney
There we
Ray.
go,
Oh,
hang on,
here I
I see Mr. Rail. Okay, Mr. Rail, do you see everyone?
I see everyone.
Okay, Ms. King is the prosecutor and she has an announcement. Go ahead, Ms. King.
This case has been accepted by the DA's office as a felony transfer, Your Honor, as of yesterday.
So is the state rescinding the plea offer?
Yes, Your Honor.
All right. Mr. Rail, Officer Milton, if you see her at the South Annex, she has to bring your client into the courtroom so we can address the case with your client. Now, unless you want to waive her presence and let her know that her case is being transferred to
I
the.
will waive her presence, Your Honor, and I do understand the case is being transferred to the DA's office.
Okay. All right. So this case is removed from state court. It will be transferred to Superior Court for the DA to accuse it as a felony matter. Officer Milton, you do not have to bring Ms. Hill as her attorney has waived her presence.
Thank you.
Do you have any other cases for me at South Annex?
I just have to get Miss Whitlock, Tawanda Whitlock, position 15 on the
On the competency calendar?
yes.
Okay. Mr. Rail, do you have any other matters to address?
None at all. Thank you,
All
Judge.
right. Thank you, sir. You have a good day. You're free to go. Okay. Miss Officer Milton is bringing Miss Whitlock, and we have one other case in courtroom 2 for the competency calendar. So I'm going to go over the SAP calendar right now and just to get an idea of what's going on.
Your Honor.
I posted.
3 South is starting to log on now. 3 South is starting to log on now, Your Honor.
I'm sorry, courtroom 2, repeat.
3 South is logging on.
Okay. 3 South is logging on. Okay.
Your Honor, what's the case number for the case on the competency calendar? I don't have that calendar.
Or can someone forward us that calendar? That would be very helpful.
Okay. Ms.
I
Champion?
think I have it. I'm checking.
Good morning, your Judge Law, and good morning, Ms. Salet. I'll handle the.
Yes, Ms. McCutcheon?
Yes,
You
I'll be
have-
handling the competency calendar, Ms. Salet, but I will send a copy to you.
Thank you,
Oh,
Ms. McCutcheon.
Thank you, Deputy.
And Ms. King, you too.
All right, good.
Good morning, Judge Law.
Good morning, Ms. Francis. Are you going to be handling the competency calendar as well?
No, Judge, I'm here for the add-on the SAP, the ancillary sheets.
Yeah.
And I believe Mrs. Sheets is also on the Zoom.
Yes, I am.
Oh, okay, I don't see Denzel Lorry yet. Officer Milton will have to, no, the courtroom would, he has to appear on one of the jail screens, and I don't see any right now. So we're going to take a pause just to go over the calendar, and then we will get back to the ones that still need to be addressed, including Denzel Lorry Sheets. Okay.
Thank you, Judge.
All right, position 1 and 2 have been arraigned and further notice for trial. Position 3, Ricky Berry, that was supposed to be arraigned. Have you spoken to Ricky Berry, Mr. McLean?
Yes, Your Honor, at the jail.
At the jail. All right, so we're still waiting for position 3 to appear. Position 4, Mr. Burnett was a plea. Position 5, Emmanuel Davis was a plea. Position 6, Angelo Della Rosa is reset to October 27. Position 7, Marvin Garlington is a plea, but he hasn't been produced yet. Position 8 is being transferred to the DA's office. Am I getting a transfer order, or was that already signed?
It's my understanding that it was signed yesterday, Your Honor.
Okay, Judge Morrow signed it. Excellent. Okay. Position 9, Ivory, Montrese Ivory. That's supposed to be a plea, but I haven't seen Mr. Ivory yet. So that's position 9. Okay. Position 10 is Mr. Jackson. I've not seen Mr. Jackson yet, so I guess the jail might be getting the folks out. Okay. Position 11 is Damian Jenkins, and that was a plea. Position 12 is N13, Jamel Lewis, and both are supposed to be an arraignment.
Your Honor, I'm sorry, sorry for any confusion there. One is a 2013 traffic matter, and he wanted to plead guilty to that. Oftentimes, not trying to take up the court's time, this may actually help. Oftentimes, there's a global offer on cases that are related, and the state would not want a person to proceed on one with a negotiated plea without going on the other. In this particular case, I think the state, I would ask the state, do y'all have a problem with him taking a plea on a 2013 traffic matter, which has nothing to do with something in the last couple of years?
Well,
yes, the state has no issue with that.
Okay, that's good.
So one of his two is the guilty, and the other one's the not guilty.
The simple batteries are not guilty,
Correct.
even though the sentences basically are time served on both cases.
Let me take a moment to take a look at that, Your Honor. I believe that
Yeah.
that is correct.
It's a balance suspended time served offer, Attorney McLean.
Right,
Okay, we have 3 South over here. Who do we have for 3 South? Officer, if you could unmute and identify who we have.
Add on position 1 and 2.
Thank you. All right, this is position 1, 2, and 3. We have Denzel Lorry, Kerchada, Sheets. Are you Mr. Sheets?
Yes, ma'am.
All right, Mr. Sheets, my name is Judge Law, and we are addressing the 3 cases pending against you in the State Court of Fulton County. First of all, you have a right to remain silent about the facts of these cases. Any statements that you make, your comments can and will be used against you. You have a right to an attorney, and representing you is Mr. Mike McLean. If Mr. McLean can wave his hand in front of the screen. Do you see him?
Yes, ma'am.
Okay, excellent. All right. And with regards to the add-on, Mr.
This is
McLean,
Mr. Sheets. I saw paperwork come in, but we have not interviewed him.
I'm sorry,
I saw Mr. Sheets' paperwork come in recently. I have not interviewed him.
you've not interviewed him.
No.
All right. Do you want to interview him today or shall I reset the case
No,
next week?
I'll talk to him in the hallway, Your Honor, if they can call me on the phone and
Okay.
find out what.
I don't see a plea offer listed.
Your Honor,
call number 6.
this defendant expressed that he was representing himself previously, and we do have a negotiated plea that was sent to him. His wife was the one that communicated. So if he can put it on the record, Your Honor, we would appreciate it. In addition to that, Judge, there was an attorney that showed up October 4th requesting that a bench warrant be lifted on his behalf. This morning, I checked all 3 cases and an entry was not made. He expressed through his wife that he's representing himself. If Your Honor could confirm with the clerk's office that he's unrepresented and with him that he wants to proceed pro se, then we can proceed, I think, Judge.
That would certainly explain why we haven't been asked to contact him. If the court would like to inquire of the defendant what his position is on representation.
I certainly will. Thank you. All right. Mr. Sheets, when we just begun my introduction, I said that you had a right to an attorney. That is a constitutional right. If you cannot afford one, Mr. Michael McLean, a highly accomplished public defense attorney, is ready and willing to represent you. Go over the terms of the plea offer and discuss your options with you in order for your best interests. Do you understand, sir?
I understand it, but I raised those rights. I represent myself, and I'm willing to take the plea that was offered to me.
All right. If you choose to represent yourself, you are responsible for all legal decisions that you make, and you are responsible for understanding how the law impacts the particular facts of your case.
Yes, ma'am.
Any legal decision that you make and how it impacts your particular case, other possible open cases that you have against you, how it impacts other matters such as, such as whether you have a residency issue and so forth and so on. I mean, you understand that you are charged with multiple counts of simple battery and battery.
Yes, ma'am.
All right. Now, here's another thing you need to understand. I don't know what the plea offer is. I have no idea. I have to wait until I hear from the prosecutor what the plea offer is. Now, I can either decide to accept it. I can also exercise judicial discretion to not accept it if I find that the plea offer is not properly reflects the allegations brought forth. I have a simple battery domestic violence in case number 19 CR 0002008Y from January 6, 2019. I have 20 CR 0022994Y accused of battery domestic violence from March 26, 2020. And then I have case number 20 CR 0046555Y from June 28th, 2020, 3 months later. And the charges are 2 counts of simple battery against a person who is pregnant at the time of the offense, and 1 count of simple battery domestic violence. So we will go through the plea hearing if you choose to represent yourself and not discuss this matter with an accomplished attorney to discuss your options. And if I find that the plea offer is not properly reflecting the gravity of these 3 cases, I will deny the plea offer and have this case scheduled for trial. Do you understand?
Yes, ma'am.
So are you sure you want to proceed without conferring with an attorney?
Yes, ma'am.
All right. So you have on record waived your right to counsel. Ms. Francis, have the plea documents been sent to Mr. Sheets so that he understands the terms of the plea offer as well as checking off all of the waiver of his rights?
They were sent to him, Judge. I'm not sure if he has completed them. If you could check with the jail staff.
Mr. Sheets, since you are representing yourself, have you completed the plea documents?
No, they haven't gave me the documents to sign or anything yet.
I repeat yourself?
I said, no, ma'am, they haven't gave me the documents to sign yet. But I got the plea offer through my wife. Was told to me what they was offering me.
So you've not looked at the plea documents, you have not understood what you've not understood what you're agreeing to, you don't understand that you'll be waiving your constitutional rights to a trial?
I understand that I be waiving my rights, but I understand what what I was read from my wife. She read the offer over the phone to me. So I haven't physically.
When did you speak with your wife?
I spoke to her yesterday, the last time I spoke to her.
Miss Francis, are any of these pleas requiring additional jail time?
No, Judge, no additional jail time is required. He's getting, the balance is probated on, it's one plea, Judge. It's a global offer that we're giving him to resolve all 3 cases.
Okay, we need to get the documents to him for him to review and sign off on them. I cannot proceed with the plea without him looking at those documents.
Judge, is it possible for the jail staff to print it for him? Because they were sent last week, I believe. His wife was supposed to print them and bring to him, and they were also sent to him. If he can have them printed for him, then we could proceed. Miss Sheets?
Yes, if I might interrupt respectfully, Your Honor. Generally, Ms. Francis, we will email the plea paperwork to one of the deputies. We'll have to inquire as to whom we should email the documents, and typically the deputy will assist with printing the documents and providing them to the defendant.
Okay.
Is that possible, one of the deputies for us?
We'll find out. We'll find out.
Thank you,
Mr. Hutchins. 3 South, we cannot proceed with the plea offer until Mr. Sheets has looked at the documents, read through them, checked off the appropriate boxes, and signed the appropriate places, including the document of waiver of counsel. So I hope that document's been sent as well. Do you have access to email? Can we send it to 3 South?
I do not have access to a printer up here, so I would have to go back down to courtroom 2 maybe.
All right.
Send it to Officer Norris and have him to print them for me, and I'll bring them back up here.
All right. Can you give us an email where we can send the documents?
And Your Honor, respectfully, Deputy, would you put the email in the chat and direct it to Ms. Francis rather than announcing it? Typically, I know the deputies want it in the chat specifically to that ESG.
Okay.
Thank you. And Ms. Francis, do you have all of the paperwork? Do you have the waiver of counsel form as well?
You're mute, Ms.
I don't have the waiver of counsel form.
I'll send that. I will send that to you so that you can forward that to the deputy as well, Ms. Francis.
Okay, thank you.
All right. 3 South, I cannot move forward Mr. Sheets' case until he's got the documents. So are we going to see him in 3 South, or are we going to see him in courtroom 2?
He will be on 3 South. I can't take him downstairs. So I have another person up here we can go forward with.
Okay, before you leave, put in the chat to Miss ASG Francis the email where she will send the documents.
Okay.
All right. Don't.
I have one other person up here while we wait on that information.
Okay, thank you. We will hold on Mr. Sheets and his plea offer.
You gonna get to me today, right, Judge?
If the documents get to you on time, because normally we conclude by 12, so that's what's holding up the delay, the paperwork.
All right, thank you so much, Judge.
All right, sir, thank you.
All right, all right.
We have Mr. Lewis, position number 12 and 13.
Okay, thank you. This is Mr. Jamel Lewis, is that correct? You need to say yes or no.
Oh, yes.
Okay. Mr. Oh, I'm sorry. Just 1 minute. Mr. McLean, at 3 South is Mr. Jamel Lewis.
I reviewed my paperwork, Your Honor. Yes, he is pleading not guilty on the simple battery case.
Okay, and he's taking a plea on the traffic matter?
Correct.
Okay. So, Mr. Lewis, you have two cases. One is from 2013, it's a traffic matter. And then one is from June 2020, and that's a simple battery case. First of all, I want to explain that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Have you spoken to Mr. McLean already?
Yes.
So you understand that you're taking a plea on the traffic matter, and we're going to arrange to have a not guilty plea in the other case. Understood?
Yes.
Okay. First, I'm going to address position 13, 21 CR 006137B, State versus Jamel Lewis. The charge is simple battery from June 11, 2020, allegedly in Fulton County. Mr. McLean, do you waive a reading of the accusation?
We do.
All right. Mr. Lewis, upon your entry of a not guilty plea, the case will be scheduled for trial. At the trial, the state would have the complete burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If they prevail, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty, Your Honor.
All right. This case is arraigned and further notice for trial. Moving on to position 12. This is 15 CR 003322. Mr. Lewis is charged with a misdemeanor offense of obscured or missing license plate, driving without a valid license, and expired or no license plates. This is from March 29, 2013. Mr. Lewis, may I place you under oath for purposes of this plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. Ms. King, is the offered time served for all three charges?
That's correct, Your Honor, 122 days.
And Mr. McLean, do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor, we do so stipulate.
Thank you. Mr. Lewis, have you consumed any medication or alcohol?
No.
All right. And have you understood the proceedings so far?
Yes.
And are you satisfied with your attorney?
Yes.
If you decide to take this plea offer, you would have to waive your right to a trial. You will not be able to confront your accuser, examine witnesses, challenge the state's evidence, present your own defenses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes.
How do you plead to the three traffic offenses brought against you?
Guilty.
Your sentence is time served. That concludes this case. Thank you.
Thank you. All right, next case on 5 South, it's gonna be position 14.
That's Denoris Nichols.
Yes, it is. 14. Yeah, I think it's just a duplicate print. Let's see.
Right. That's also not guilty, and I believe bond is moot.
Oh. And we have 5 South, and we have Mr. Denoris Nichols. Is that correct, sir?
Yes.
All right, Mr. Nichols, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Mike McLean. Mr. McLean, excuse me, Mr. Nichols, your case is 22 CR 006751J. You're accused of simple battery domestic violence from October 30th, 2019. This is going to be in an arraignment. So, Mr. McLean, do you waive a reading of the accusation?
We do. We have a copy.
Mr. Nichols, upon your entry of a not guilty plea to the misdemeanor offense I've listed, your case will be scheduled for trial. At the time of the trial, the prosecutor has the complete burden to prove the charge against you beyond a reasonable doubt. If they prevail, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
Case has been arraigned and further notice for trial. What's the issue with bond, Mr. McLean?
There is no issue with Vaughn. He has another case and
I see.
so it's moot.
Okay, so this case is further notice of trial and it's concluded. Thank you.
Position 15, Mr. Wonder Whitlock.
Is that on the competency calendar?
Yes, Your Honor.
I think it was, is Mr. Howard here? ASG Derek Howard?
I'll give him a call, Judge. Let him know you're calling.
Okay,
Judge, can we finish up 5 South? I still have four people.
okay. Deputy Milton, we'll have to hold on, Ms. Whitlock until, Defense Attorney Derek Howard appears. Okay,
No problem, Your Honor.
all right. 5 South, you said you had another case?
Position 3, Barry.
All right,
And Ricky Berry is not guilty and bond is moot.
thank you. Mr. Ricky Ferrando Berry, case number 22 CR 002-699Y, accused of battery, domestic violence, and criminal trespass from April 15th, 2020. Mr. Berry, you've been advised, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have the right to an attorney, and representing you is Mr. Michael McLean. Do you see him on the screen? You see him on the screen? Okay. Do we waive a reading of the accusation, Mr. McLean?
We do, we don't need it waived. We don't need it read to us, correct? We
All
have a
right.
copy.
Thank you. Mr. Berry, I've listed the 2 charges brought against you. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the state, the prosecutor, has the complete burden to prove the charges against you beyond a reasonable doubt. If they prevail, you could be convicted for up to a year in prison and or up to a $1,000 fine for each convicted offense. Given this information, how do you plead?
Not guilty.
Your case has been arraigned and further notice of the trial. Thank you. That concludes the matter.
All right, position 10. I got you.
Do you have Garlington and Ivory by any chance?
I do.
Deputy at 5 South, do you have?
Yes, I have position 7 and 9, but can we do position 10?
All right, great. Thank you. We have Fremonis Jaleel Jackson. Is that correct? Are you Mr. Jackson?
Yes, ma'am.
All right. Mr. Jackson, my name is Judge Lal, and we are addressing your case 22 cases. First one, oh dear.
I think Jackson has one.
I have 2 cases listed.
Yes,
Oh,
I offered
that's
a
all.
global for to his other open case as well.
All right.
I'm sorry, I meant to say there was one position on the calendar, but that's correct.
Position 10 with Mr. Jackson, he's listed with 2 separate cases, and this is going to be a plea hearing. Is that correct?
Uh,
No, it's an arraignment
It's just an arraignment.
on 2 separate cases. Is that correct?
Yes.
All right. Let me get the case numbers correct. All right. Mr. Jackson, we are addressing 2 cases, and from what I understand from your attorney, you're pleading not guilty in both cases and having those cases scheduled for a trial. Is that correct?
Yes, ma'am. Well, I knew that I was pleading not guilty and scheduling for a trial for the battery, this misdemeanor case, but I haven't spoken to anybody about my felony case.
No, I'm not, you've got 2 misdemeanor cases.
Oh, yes, ma'am.
Let me list them for you. It's 22 CR 006873E. You're charged with battery against a female who is pregnant, and this is from August 17, 2021. You have a second case, 21 CR 004319E, in which you are charged with battery against a female who is pregnant, and that is from August 17. Same case.
Yes, ma'am.
All right. Can somebody explain to me why we have two batteries on the same day in two separate
So,
cases?
Your Honor, originally it was charged as a battery family violence, but upon accusing it, it was discovered that the young lady was pregnant. So it was accused as a battery against a female who's pregnant. But the warrant was taken out for a battery of family violence because of the relationship between the parties.
So you have to dead docket or null pros one of the cases.
That is typically I was handled. I just wasn't there when it was done, so I wasn't sure the instructions from the deputy that was supervising that day. I will reach out to my supervisor or Deputy McCutcheon if you will give me the okay to do so. I will handle that today.
If I can just inquire, was an added charge? Was a charge added to the very same accusation?
No, it was amended.
So it's an amended accusation with the same accusation number.
That is correct, but the other charge is still out there. The original charge is still out there, kind of floating around.
If you can just email me, Ms. King, because typically we should have just amended the accusation or either added a charge and keep the same number so that all charges are on the same accusation. But if you can just email me the case numbers and I'll look them up.
Will do. Thank you so much.
Which position's on the calendar? I have the calendar up. Which positions?
It's position 10.
10. All right, I'll look that up. Thank you.
Yes,
and
if
just
you
let
search
me-
under the name, you'll see it all pop up.
Okay.
I think the 6873E case should be null pros because the amended accusation was filed in 4319E. Mr. Jackson, I apologize for this complicated little matter, but you have two cases pending against you for the same offense. So I'm trying to see which case is going to be dismissed so that we can arraign you on the correct case. So if you just be patient, we will sort this out and deal with it in the next few minutes, okay?
Yes, ma'am.
All right. Ms. McCutcheon,
Yes,
please let
Judge.
me know as soon as possible which case is going to be dismissed.
Judge, and what were the numbers again, Ms. Your Honor?
21 CR 004319E, and that case has the amended accusation.
Yeah, which position on the calendar respectfully?
Oh, 10, position
thank you.
10.
Thank you,
Both
Your Honor.
cases are listed on position 10.
All right, thank you.
All right, thank you. 5 South, do you have any other cases I can address?
Yes, I have position 9 and 7. We can address position 9, Ivory.
Okay, thank you.
Those are both negotiated, please.
All right.
Your Honor, I have put an email address they can send the plea paperwork to. I put it in the chat to Ms. King.
Yes, and I forwarded it to ASG Francis. She'll be sending it over right now.
All right, thank you.
Thank you for that.
No problem.
Okay, position 9, 22 CR 006280C, State versus Montrese Ivory. Are you Mr. Ivory?
Yes, ma'am.
Mr. Ivory, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you presently is Mr. Michael McLean. Do you see him on the Zoom?
Yes, ma'am.
Okay.
Your Honor, if I may interject, at one point, Mr. Ivory was seen in the jail and he said Ms. McLeod was representing him. That has not been confirmed. And that was the last we had heard about that.
I did see Miss McLeod on the Zoom. Miss Maureen McLeod, are you on the Zoom?
I am here, Your Honor. Yes, I am.
Thank you. Miss McLeod, your client is Montrese Ivory?
Ivory? No, Your Honor.
He's at
McLeod,
5,
the
he's at,
bond.
he's at 5 South. Is listed as a conflict case. Mr. Ivory, with which attorney did you speak?
I spoke with Mike McLean last night. But Miss Maureen McLeod was at my first appearance.
Right, and he should proceed with Ms. McLeod if there is a conflict, and it should not be any problem at all to do that.
I'm happy to speak with him, Your Honor.
All right. We're gonna 5 South. Do you have? Oh, you have position 7.
Yes, can we do position 7 before we do the breakout?
Yeah, please do. All right, Mr. Jackson, we're gonna have you speak to Ms. McLeod. Ms. McLeod, if you can hold, I'm gonna take one plea and then put 5 South in a breakout room with you. Okay?
That will be fine, Your Honor. Thank you.
Thank you. He's got a $3,000 cash bond on that case. Just FYI. All right, position 7. I have Marvin Garlington. Is that correct?
Yes.
Correct.
Mr. Garlington, just want to remind you that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney and representing you. Hopefully it's Mr. Michael McLean. Is that correct?
Yes, Your Honor.
All right. Mr. Garlington, you're accused of battery, domestic violence from September 19, 2022. I understand this is going to be a negotiated plea. May I place you under oath?
Yes. Yes.
Raise your right hand. Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes.
Thank you, sir. Thank you. Ms. King, what's the plea offer for Mr. Garlington?
It is 12 months to serve 58 days, credit for time served 29 days with the balance probated, a FVIP course, no further contact, a stay away, and no drugs, alcohol, or weapons. The stay away address is 3200 Stone Road Southwest, and no further contact with Carla Leonard, C-A-R-L-A, last name L-E-O-N-A-R-D.
Sorry?
L-E-O-N-A-R-D.
Oh, Leonard, okay. All right. Okay. Mr. McLean, are those the terms to which your clients agreed, and do you stipulate to the factual basis, venue, and ID?
They are the agreed terms, and we do so stipulate, Your Honor.
Thank you. Mr. Garlington, have you consumed any medication or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
This is 1 count of battery, domestic violence. Is anyone forcing you or inducing you to take a guilty plea in this case?
No, ma'am.
If you decide to enter a guilty plea, you would have to waive your constitutional right to a trial in the future. You will not be able to have the assistance of counsel to confront your accuser, examine witnesses, challenge the state's evidence, present your own defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am.
How do you plead to 1 count of battery, domestic violence?
Guilty.
Your sentence is 12 months to serve 58 days, credit for time served 29 days. It appears that your jail time is concluded, and if you have no other cases holding you at the jail, you shall report to probation next Thursday at 132 Mitchell Street in downtown Atlanta. Do you understand?
Yes, ma'am. But I do have a case that I'm waiting to burn out on still.
Okay, so you have another case holding you?
Yes, 2, Your Honor.
Okay, so in other words, once you are released, you have to report to the probation office at 132 Mitchell Street. They're normally open on Tuesday, Wednesday, Thursday, and you must report within 7 days of being released.
Yes, ma'am.
Once you are on probation, you will complete a domestic violence intervention program course. That's a 6-month-long course. The classes are weekly, and you shall pay for that course out of your own pocket. I will waive your probation fees for the first 7 months of probation, and once you're done with the course, you can go non-reporting. Do you understand?
Yes, ma'am.
At all times while you are on active or non-reporting probation, You are to stay away from 3200 Stone Road in Southwest Atlanta. You cannot return to that location. You must stay 200 yards away. That's the length of 2 football fields. You're also to have no contact with Carla Lennon. You're to stay 200 yards away from her. Do not communicate with her in person, through a phone, through a computer, through a third party, and definitely not on social media. Understood?
Yes, ma'am.
No illegal drugs, no alcohol, and no weapons and no firearms.
Yes, ma'am.
Do you have any questions?
No.
All right, that concludes your plea hearing. Thank you.
Thank you.
All right, can we go back to position 9?
Okay.
And Ivory do not need a breakout session.
Thank you. Miss Grace, if we can place Miss Maureen McLeod, who is on the...
Judge, we don't need a breakout session. He's spoken to McLeod over the phone.
Oh, excellent.
Yeah, I've already
Okay.
spoken, Your Honor.
All right, excellent. Then what is the announcement for State versus Montrese Ivory, position 9?
My client will be taking a plea, Your Honor. It's a negotiated plea.
All right, thank you. Mr. Ivory, you've already been advised of your right to remain silent. Your attorney is Ms. Maureen McLeod. This is going to be a negotiated plea on 1 count of simple battery domestic violence in 22 CR 006-280C. Could you please raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. King, what is the plea offer for Mr. Ivory?
It is 12 months to serve 70 days, credit for time served 35 days with the balance probated, a FVIP course, no further contact, stay away, and no drugs, alcohol, or weapons. The stay away address is 4455 Fulton Industrial Boulevard in Atlanta. And the no further contact is with LaWanda Rucker, LAWANDA, last name RUCKER.
Thank you. Mr. McLean Miss McLeod, are
Yes,
those
Your
the
Honor.
terms? Are those the terms?
Those are the terms based on my understanding of the state's offer, Your Honor.
And do you stipulate to the factual basis, venue, and ID?
I do, Your Honor.
All right, thank you. Mr. Ivory, you've already been sworn with regards to this case. Have you consumed any medication or alcohol recently?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
Okay. And I know there was a switch of attorneys, a little complication, but when you've spoken to Ms. McLeod and she's explained the terms, your rights, your options, and so forth, are you satisfied with the representation?
Yes, very much so.
Okay. And is anyone forcing you to take a plea today?
No, ma'am. No, Your Honor.
All right. And Mr. Ivory, if you decide to plead guilty to simple battery domestic violence, you will have to waive your constitutional right to a trial, to go back to court to confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, Your Honor.
And how do you plead?
Guilty.
Your sentence is 12 months to serve 70 days. Credit for time served, 35 days. If you have no other cases holding you at the jail, then you will be released within 24 hours. You must report to probation next Thursday. That's presuming you have no other holds. Next Thursday at 132 Mitchell Street in downtown Atlanta. They will create a probation case, and while you're in probation, you will complete a domestic violence intervention program, which is a 6-month-long program of weekly classes. You will remain on probation until you complete the classes. If you've completed the classes, then your probation will be non-reporting. Do you understand?
So yes, I have to complete the classes and then I'll be back on non-reporting.
On non-reporting, right. So make sure you complete the classes as soon as possible. I will waive your probation fees for the first 7 months. So the sooner you get it done, the less expensive it will be for you.
Thank you, Your Honor.
Right? But if you're not done with the classes within 7 months, you must continue reporting to probation and start paying probation fees in the 8th month onwards.
I understand.
All right. Whether you are on active or non-reporting probation, you are to stay away from the 40455 Fulton Industrial Boulevard location in Atlanta, and you cannot have any contact with LaWanda Rucker, which means staying 200 yards away from her, not contacting her in person or in any other way, including social media, and no alcohol, no illegal drugs, and no weapons.
Yes, Your Honor.
That concludes your case. Thank you.
All
Thank
right,
you,
can
Ms.
we go
McLeod.
back-
Appreciate it.
Can we go back to Jackson case?
Thank you, Your Honor.
I'm sorry, Deputy, what was your announcement?
Can we go back to Jackson, position 10 case?
Ms. King, what's the announcement on the two cases against Mr. Jackson? Oh, Ms. McCutcheon?
Yes, Judge. I've looked at both cases. The 22 CR 006873E is a duplicate to the 21 CR 004319E. The case ended in 4319E. We filed on August the 18th of 2021, the battery family violence. Then a battery against a pregnant female was added to that case on October the 13th of 2022. It just did not have an accusation number on it. But in case manager, both those charges are showing associated with the 21 CR case number.
Okay, so we're going to dismiss 22 CR.
That's correct, Judge.
006873E as a duplicate case?
Yes, Your Honor. And I'm filing, I will send to, is it Miss Lewis today?
To April Champion.
April Champion. I will send a no cross order to Miss Champion.
Thank you.
Thank
All
you,
right.
Deputy.
And I just want to clarify one other thing. He was originally charged with battery, domestic violence. That charge has now been amended to battery, family violence against a pregnant woman. Is that correct?
No, Your Honor. Actually, a charge, we still have the battery family violence on the 21 CR case. The battery against a female who was pregnant was added to that 21 CR case. In case manager, if you pull up the accusations, it shows an added charge filed on October 13th of 2022 for the battery against a female who is pregnant. And Ms. King, is the plea offer to both charges, or are we dismissing one, or is it a plea to both?
It was only to one, and we would dismiss the other. I just wasn't sure which one you would want me to dismiss.
It does not matter. Both cases are showing up in case manager, Your Honor, as associated with the 21 CR. So why don't we go, Ms. King, the battery family violence. The battery family violence on 21 CR 004319E, and we will null pros the battery against a female who is pregnant.
I don't know about that, Ms. McCutcheon.
Why is that, Judge?
On October 13th, 2022.
We added a charge. We didn't, it
It
shows.
says, okay, I'm
charge.
so sorry. Yes, it's an added accusation, but it was
Correct.
entered as an amended accusation. Okay. I
Yes,
see.
Judge, and I think that's the issue. It was entered as an amended when it should have been entered as an added. And if you will see, it does not have the accusation number on it. Can the court see that?
Yes, I can see that.
Yes,
So-
and so Judge, to avoid any confusion with that, which is why the state is moving to null pros the battery against the female who is pregnant and go with the originally filed charge on August 18th of 2021 in 21 CR 004319E, which is battery family violence.
Okay. Just, this is not an issue, Ms. Champion. Let's look at the case 21 CR 004319E. I see only one charge there because of the complication of the second case, which is now null crossed. So we have to amend.
So on the 21 case, are they trying to have two charges or one charge?
So there was
Only one.
there were only supposed to be two charges, but there's listed as only one charge. Unfortunately, the use of the word amended on October 13 created a bit of a complication. And I understand what the state is trying to do. I just want to make sure that it reflects correctly on.
So it should not have been amended, it just should have been an added charge. It should be battery against a female who is pregnant plus the battery family violence charge.
Correct, correct.
Is that correct, Stacey?
Yeah.
Yes,
Ms.
yeah,
McCutcheon?
that is correct.
It should have been an added charge, not an amended charge. Your Honor, I can fix that, but if I fix it, it's going to delay the court. It would take a while because I'd have to go into the system, fix it, file it down, and then the clerk would have to see it and then pull it and process it. That usually takes at least sometimes up to an hour. It just depends, Judge.
And what are we doing? Are we doing an arraignment?
Yes, Your Honor.
Okay. We're going to arraign the case on a battery family violence. It's on record that the battery against a female who is pregnant is going to be null prost. And then, Ms. McCutcheon, you can fix it at your leisure. How about
Yes,
that?
thank you, Your Honor. Yes. So I will prepare the null pros on the 22 CR case, and I will get with Ms. King and we will discuss what we're going to do with the 21 CR. But I will prepare that and I will email it, the null pros, to Ms. Champion.
Okay.
And I'll just put on the record so that the defense is aware, there are no, I'm looking to see if there are any statute of limitations issues. And due to the, is this your case, Mr. McCain?
Yes.
Right, I'm looking at the incident date, which typically the statute would have run on August the 17th of 2022, but due to the judicial emergency, it has told, so we will add that additional charge. Thank you.
All right. Now, Mr. Jackson, I'm going to address you. All right?
Yes, ma'am.
All right. You have one case. The case number is 21 CR 004319E. That's the only case. The other case is going to be dismissed, so that's out of the picture. You have one charge against you and just one charge. And the only charge against you is battery family violence, allegedly from August 17, 2021 in Fulton County, Georgia. Okay?
Yes, ma'am.
As long as you and I are on the same page, I'm a happy puppy, okay? And the accusation that was filed on August 18, 2021, that is the only charge brought against you with regards to a Ellaby China. That's the only charge. And Mr. McLean, are we waiving a reading of that accusation from August 18, 2021?
We are waiving that reading, Your Honor.
All right. So, Mr. Jackson, to this one and only one charge, upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the state will, well, actually, I don't even have to arraign the case. On June 21st, 2022, a waiver of arraignment was filed by Derek Howard. We good, Mr. McLean?
We're good.
Okay. So, Mr. Jackson, you've already entered a not guilty plea. We're going to fast track this case to trial. Okay?
Yes, ma'am.
All right. So do you have any questions about the case brought against you in terms of trial, in terms of what charge is brought against you?
No, ma'am. I understand what you just said to me about my trial. I just had one question. Would I know before I leave today when my trial date will be?
No. The case is, I can tell you this much. The case is with Judge Jane Morrison. Okay?
Yes.
It looks like the trial should have been scheduled because they're getting ready with a lot of documents having been filed with regards to jury charges, state intent to present similar transactions, so forth. All this has been filed on October 13th. So I think it will be pretty soon for you.
Yes, ma'am.
Like all the documentation for preparation of trial has already been ongoing since on October 13th, 2022. Okay?
Yes, ma'am.
And Your Honor, respectfully, if I might add, Mr. McCain, there are no statute of limitations issues, and disregard what I said about tolling. I misspoke. The incident date is alleged to have been August of 2021, not 2020. So there are no statute of limitations issues.
Correct. Okay.
Thank you, Your Honor.
Mr. Jackson, anything else you want to ask me before I move on to the next case?
No, ma'am, thank you.
All right. In terms of bond, unfortunately, let me see. Your bond was forfeited on April 22nd, 2022. Looks like you had a bench warrant. So that's the situation. Has Mr. McLean explained that to you?
Your Honor, the attorney assigned to that case will be in touch with the attorney assigned to his other case. They'll discuss that, but we believe bond to be effectively moved this time.
Do you know who is the public defender assigned to Judge Morrison's case?
Rose Woodbury.
Okay.
The other person is Alyssa Jones.
All right. So, Mr. Jackson, the public defense attorney assigned to Judge Morrison's courtroom will contact you and discuss the options with regards to your bond. You presently have a $4,000 surety bond due to the bond forfeit, due to the failure to appear last time. Okay?
So I do have a $4,000 bond.
Yeah, that's what it shows. If you make the $4,000 bond, I'm not sure why it's still up there since the other, it indicates a bond forfeiture, but that's what's on the case manager right now. Okay?
All right, thank you, ma'am.
Okay. There is a motion to revoke the bond filed on October 13th. So all that's going to be addressed before Judge Morrison. All right, and we will send an email to Ms. Rosalie Berry to address this case. All right, that concludes Mr. Jackson's case. Thank you.
Thank you.
Ms. Champion, if you can send an email to Ms. Rosalie Berry, PD's office. Do you know it? Do you have it, Mr. McKay?
It's ROSCWOOD.
Oh, that's too fast for us. We're a little.
Oh, I'm sorry. It's ROSE dot WOODBURY. And then the usual at FultonCountyGA.gov.
Yeah. Okay. Thank you. Okay. Officer Milton, are we ready?
I'm ready, but I don't see Mr. Howard. She just stepped to the restroom. So here she comes. Okay, sit down. We're ready for you.
Hey. Is that Miss Whitlock?
Yes, ma'am.
Officer Milton, can you identify the case again, please? I'm sorry, it's been
It's
a while.
position 15 on the composite calendar.
Okay, Mr. Howard, are you present? Or who is the ASG for the competency calendar?
And Your Honor, I believe Mr. Howard is inside of the jail. I've been trying to contact him, but I'll continue to contact him, Judge, but I do believe he's inside of the jail.
Oh, boy. Is he the only ASG doing the competency calendar?
I believe so, Judge. Just let me give him a call and see where he's at.
Is there anyone else on the SAP calendar I can address? All right, folks, Miss Whitlock, hang tight. We need to get your attorney on the Zoom. So we're still trying to get that attorney on the Zoom. Yeah, I know. Is anyone at the jail? Have you got position 16, Daryl Harris and Carlos Peterson?
Your Honor, Carlos Peterson, I believe, was released.
All right, that's. And position 25 is reset to October 25th.
That's correct, Judge.
And position 26 and 27 are reset to October 27th.
That's correct, Judge. And I also just spoke with Mr. Howard. He's logging on fairly shortly here.
Thank you. So we're still curious about Daryl Harris. I don't think I've even seen Mr. Paris.
That's my case, Judge. If the deputies can get him, it should be a negotiated plea.
Your Honor, she went to the restroom. She'll be right back.
Sure, why not?
Couldn't hold it.
No problem. Hey, I like that pink. That's really nice. I'm glad
Thank you.
it looks really, really good. Okay.
Thank you.
Just a spot of color to the Zoom. Okay. Okay, so have we addressed Denzel Leroy Sheets? Does he have the paperwork?
I sent it to them, Judge.
And have you heard from them?
Not yet, no.
Oh my goodness. Hmm. Well, I promised to address Mr. Denzel Leroy Sheets. I hope I can reach him. Folks, just going.
I sent them an email, Judge, so I'm waiting for a response.
Waiting for Mr. Derek Howard to sign on. So just to go over the SAP calendar, position 1 and 2 are arraigned. Position 3 is arraigned. Position 4 is a plea. Position 5 is a plea. That was Emmanuel Davis. Position 6 is reset 1027. Position 7, Darlington is a plea. Position 8 is transferred to the DA's office. Position 9 is a plea. Position 10 is a arraignment and further notice for trial. Position 11, Jenkins, is a plea. Position 12 is a plea. 13, Jamel Lewis, is an arraignment and further notice for trial. 14, Nichols, is arraigned and further notice for trial. 15 was arraigned and further notice for trial. Position 16, Daryl Paris, is on hold. Position 17 was released. Position 18 was reset to November 3rd, 2022. Positions 19 was a plea. 20, Shelton, is arraigned and further notice for trial. 21 was a plea. 22, Teague, and 23, Teague, and 24, Teague were all arraigned and further notice for trial. 25 is reset to October 25th. 26 and 27, Wabibi, is reset to October 27th. So I'm waiting to do the plea on the add-on calendar with self-represented Mr. Sheets and Mr. Howard.
He's still logging on, Judge. Just there you go.
And I'm waiting on the state to produce Daryl Paris, position number 16. Not the state, the jail.
Your Honor, position number 25, Mr. Jacory Vaughn. I have filed a motion in that case, Your Honor, for his bond to be modified.
25?
Yes, Your Honor, Jacory Vaughn.
I'm sorry, Ms. McLeod, I don't have a Jacory Vaughn on the state all purpose.
Oh, yeah, Judge, that's 25, position 25, Judge. And Ms. McLeod, I didn't know that he was represented by conflict counsel. Okay, I'll make that note. Thank you so much.
You're welcome.
Oh, okay. So this is, so it's not reset to October 25th, are we?
It is, Judge, unless Ms. McLeod would like to change that date.
Well, I just wanted the issue of his bond to be addressed as soon as possible, Your Honor, because he has been in jail now for over 2 weeks. I think since October 6th. He has a cash bond of 10,000 and he's not been able to do that.
And the motion was just filed today.
Yes, Your Honor.
All right. I'm going to take the motion up on the 25th so the state can review your motion. I don't have any indication that there was a bond modification requested.
Yes, Your Honor.
All right. So we're going to stay with the 25th, and whoever is challenging that bond from the state, the motion was just filed today.
Thank you, Your Honor.
All right. Thank you.
You ready, Your Honor?
Mr. Howard, Derek Howard, are you with us?
Yes, Judge. Good morning.
Good morning, sir. Okay, Mr. Howard. Okay. Let's go ahead. I have Miss Whitlock at the Union City location with Deputy Milton. Do you see her?
Yes, I do see
All
her.
right. Do you want to address this in a breakout?
Yes, Judge, she's on the conference call. Yes.
Okay, all right. This is State versus Tawanda Whitlock, 21 CR 005-873E. Miss Whitlock, you've been accused of criminal trespass and theft by taking. You have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and your attorney is Derek Howard. Do you see Mr. Howard on the screen?
Yes, ma'am.
Okay. Ms. Whitlock, I'm going to ask Deputy Milton to mute your screen. Deputy Milton, if you can mute South Annex, please. Okay. We are going to disappear from the screen in what we call a breakout room. We are still addressing your case, but because of the sensitive nature of your charges, we are going to do it in a breakout room. So if you see us disappear, please don't worry. We'll be back very soon, okay? All right. Miss Grace, if you can place Mr. Derek Howard, myself, and Miss McCutcheon.
Your Honor, may I be placed in the breakout room as well to observe?
Yes, and Miss Salette in the breakout room. There are 4 of us in the breakout room. Me, Mr. Howard, Miss McCutcheon, and Miss Salette.
Okay.
Thank you, Miss Grace.
Is 3 South on? Can you advise if you sent the completed plea paperwork to?
It should be in right now. Officer Matthew is sending it.
I'm sorry?
Officer Matthew is sending it now. It's in right.
Okay, thank you.
All right, addressing Ms. Whitlock's case, Ms. Whitlock, so we have spoken with your attorney, Mr. Derek Howard, prosecutor, Ms. Michelle McCutcheon, and based on the evaluation that was done, I will be signing a release order for you to be placed in the custody of your mother, Carolyn Whitlock. Can you unmute the screen, please?
I can stay with my mom and my kids at my house, my apartment.
You can stay with your mom and you stay in accordance with how she wants it. Do you understand?
Well, I'm talking about the apartment that I got. I can stay with them.
If your mother lives in that apartment, you can stay with that apartment. If your mother lives at a different place, you have to live in that different place.
Okay, yes, ma'am.
But you will be released to the investigator who will transport you to your mother. Understood?
Do I get out today?
No, it will be on October 26th, next Wednesday.
Okay.
And then once you are released, You must make sure that you comply with the plan of treatment that's been already prescribed for you.
Did they say I was going to Tennessee or was I going to my house?
No, it's going to be here.
Okay.
And you need to make sure that you go into the program that's already been agreed to and that you're compliant with the treatment and anything else that they provide you. Understood?
Yes, ma'am.
You must also be compliant with your medication. Understood?
What's medication, ma'am?
Well,
you got something to do with that I have custody of my mom.
So Ms. Whitlock, we're gonna come to the jail and make sure you understand the same medications you're taking now. We're gonna come to the jail and go over everything with you.
Understood?
When?
Francis, did you get the plea paperwork?
Mr. Howard, when can she anticipate? Courtroom 2, please mute. Ms. Grace, please mute courtroom 2. Thank you.
Yeah, I can come by tomorrow, Ms. Whitlock.
Okay.
All right.
Okay. And while you are released and living with your mother and only your mother, Carolyn Whitlock, you cannot return to 1150 Collier Road in Northwest Atlanta. You cannot return to that apartment complex. Do you understand?
Yes, ma'am. Why?
You got to stay away from that property, that entire apartment complex. Understood?
Yes, ma'am.
And you also have to stay away from Eleanor McAlpin, the person who lives there.
That's the lady or man?
I don't understand.
That's a lady or a man?
Is a lady, Eleanor McAlpin. Okay. I think I've covered everything. Make sure that you comply with the program and that there is no, you don't consume any illegal drugs, no alcohol and no weapons. Understood?
Yes, ma'am.
All right. That concludes the hearing for Ms. Whitlock. Thank you.
Have a good day, everybody.
Thank you, Officer Milton. Take care. Mhm.
Thanks, Officer Milton.
Okay, before I return to the competency calendar issue, we have Mr. Sheets, position 1, 2, and 3 on the add-on calendar.
Your Honor, I did get the plea paperwork from them, but I did not receive the waiver of right to counsel form signed by him. I just asked them for it.
3 South, do you have a document that's titled waiver of counsel or waiver of right of counsel? 3 South?
Hold on, Judge, we checking now. We should have
Okay.
a copy of this one.
Not it. Yeah, that's it right there.
That one right there, yeah.
I thought it. This the paperwork right here.
Yes, can it be emailed to us as well, please?
Well, I'm not near a computer. Somebody did it for me so I can come back up here to get him. So I
Okay.
have him come get him.
Hang on. Deputy, do you have the document signed by Mr. Sheets where he's agreed to waive his right to counsel?
Hold on, he's doing it now.
No, if you have it, then you can email it later to Ms.
Okay,
Francis.
Okay.
All right, we have the other documents. We can proceed with that. I just want to be sure that you have his waiver of right of counsel with you. Okay, Mr. Sheets, have you signed off on the waiver of counsel?
Yes, ma'am.
All right, please give that to the deputy and she will email that to Ms. Francis. Thank you. All right. Deputy, do you have the document signed off? It says waiver of counsel.
I have it, yes, I do.
Thank you. All right, please email that as soon as you can to Prosecutor Francis. Thank you. All right, we are addressing the add-on calendar for today's SAP calendar, which is State versus Densleroy Rashada Sheets. Mr. Sheets has 3 separate cases, 19 CR 000-208Y, simple battery domestic violence. Second case, 20 CR 0022994Y, battery domestic violence on March 26, 2020. And the third case, Denzel Leroy Sheets, charged with simple battery against a person who is pregnant, 2 counts. And the third count of simple battery domestic violence from June 28, 2020. So these are 3 separate cases involving allegations of misdemeanor violence stemming from a January 6, 2019 through June 28, 2020. Mr. Sheets, you've been advised of your right to remain silent. Anything you say about the facts of these cases in open court, your statements can and will be used against you. You have a right to an attorney. You've already been advised of your rights to an attorney and advised of the repercussions if you waive your right to counsel and choose to represent yourself. As we said, I'm assuming that you understand the law and how it applies to your particular set of facts for all 3 cases. You have read the waiver of counsel form, Mr. Sheets?
Yes, ma'am.
And you still want to proceed self-represented?
Yes, ma'am.
And you have signed the form that says that you waive your right to counsel, correct?
Yes, ma'am.
All right. For purposes of this hearing, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
I'm going to first hear the plea offer from the state with regards to 3 cases. Please keep in mind that the court has the discretion to deny the plea offer and set the case for trial if it finds that it's not reflective of the charges or the cases brought against you. Thank you. Ms. Francis, what's the global offer, please?
Yes, Judge, the global offer is a guilty plea to battery family violence on case number 20 CR 002294Y. The other cases, 19 CR 000208Y and 20 CR 004655Y will be null pros. The conditions of the battery family violence guilty plea will be 12 months to serve 60 days, credit for time served, 24 days, the balance will be probated. Family violence intervention program, 100 hours of community service, parenting classes, and no further violent contact with the victim, Shanika Sheets. Shanika spelled S-H-I-N-E-K-A, Sheets, S-H-E-E-T-S.
What did you say about position 3? What are you doing with those charges?
They'll be null pros, Judge.
All 3 of them?
Yes, Judge.
Okay, so case on position 3, that entire case is null pros. So he'll be pleading guilty to 2 cases only.
No, Judge, he's pleading guilty to the battery family violence in 20 CR 002294Y.
The simple battery domestic violence.
No, Judge, the battery family violence is what he's pleading guilty to.
Which is position 2.
Oh, I'm sorry, Judge. I don't have the calendar in front of me. I'm sorry.
Let me just clarify. The 19 CR ending in 208. Is the state requiring a guilty plea to the simple battery domestic violence?
No, Judge, that one is going to be null pros along with the one that ends 4655Y.
So position 1, simple battery family violence null pros. Okay.
Yes, Judge.
And the case ending in 655Y?
Will be null pros as well, Judge.
The entire case?
Yes, Judge.
Okay. So the only case remaining against Mr. Sheets is position 2, ending in 224994Y, correct?
Yes, Judge.
Okay. Okay, Mr. Sheets, it appears that the case from January 6, 2019 is going to be dismissed, and the case from June 28, 2020 is going to be dismissed. So you're pleading guilty to 1 count of battery domestic violence from March 26, 2020. Is that your understanding?
Yes, ma'am.
Okay. All right, and Ms. Francis has already itemized all the terms that she's going to require from you with regards to this case. Mr. Sheets, if you decide to plead guilty to battery domestic violence, you will have to agree and stipulate that the factual basis for this one charge, in other words, the factual allegation supporting the charge of battery domestic violence, the location in Fulton County, and the perpetrator, that is you, are all true and correct. Do you so agree and stipulate?
Yes, ma'am.
Are you under the influence of any kind of medication or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And are you being forced or induced to take this plea offer?
No, ma'am.
And you understand that you have additional jail time because it's 60 days, which means you have about 3 days left. Is that correct?
No, Judge, we're suspending, we're probating the balance. He has already done in excess of, in regards to all these cases, he's done in excess of 30 days.
Okay, so it's 12 months to serve 60 days credit for time served 30 days then, not
Yes.
24.
Yes,
Okay.
Judge, you can correct that, thanks.
All right. Yeah, I had 24 initially. Okay. So your jail time for this case is concluded and you'll be reporting to probation if you have no other holds. Is that your understanding, Mr. Sheets?
Yes, ma'am.
All right. And you understand you have to do the parenting class, community service, and not have any violent or physical, verbal or physical altercations with Shanika Sheets.
I understand. Yes, yes, ma'am.
And the family violence intervention program as well,
Yeah,
Judge.
definitely, yes. Okay. So, Mr. Sheets, you understand that if you accept this guilt, if you enter this guilty plea, you're waiving your right to a trial before a judge or a jury. You will not be able to have a trial where you can confront your accuser, examine witnesses, challenge the state's evidence, to present your own defenses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to waive these rights?
Yes, ma'am. I have one question though.
Yeah.
About the community service. I already volunteered coach Little League football. Can I use that as my community service?
Repeat.
I already volunteered doing community service doing at the rec, coaching Little League football. Can I use that as my community service?
I don't know. As long as it's a registered nonprofit company, you can do it. But if it's not a registered nonprofit company,
Because I'm already disabled. I have with one leg, and I know I
Okay.
can't do physical work. That's why.
all right. Mr. Sheets, I'm going to require you to do 100 hours of voluntary community service at a registered nonprofit agency that's acceptable to the probation officer. The one that you're identifying, I don't know it at all, so I'm going to disallow it. You're going to do 100 hours of voluntary community service at a nonprofit agency like Goodwill, Salvation Army, the Food Bank, and so forth. But the one,
Alright.
the sports league that you're identifying, no, I'm not going to allow that.
Okay.
All right?
Thank you.
Do you still want to enter a plea?
Yes, ma'am.
So with regard to this particular charge, battery domestic violence in case 20 CR 0022941, how do you plead?
Guilty, ma'am.
You done, Mr. Howard?
Your sentence is 12 months to serve 60 days, credit for time served 30 days. The balance will be on probation. You will report to probation at 132 Mitchell Street in downtown Atlanta next Thursday. You understand?
Yes, ma'am.
Next Thursday, and where you will meet with your probation officer.
Do I have to pay any fees?
Well, listen very carefully.
Okay.
You have to do a 6-month program. 6-month program, we call that the Family Violence Intervention Program. Those are weekly classes. You must enroll in that program within 30 days of being released. Within 30 days of being released, you must enroll in that class. That means by your second visit to your probation officer, You must show proof that you are enrolled.
I'm doing it as soon as I get out.
You have to complete 100 hours of voluntary community service at any nonprofit registered agency acceptable to your probation officer. The one that you've identified is disallowed.
Okay,
You have to complete parenting classes, at least one parenting class at a program that's acceptable to your probation officer.
okay,
You are to have no physical and no verbal altercations with Shanika Sheets.
okay,
If there are any future altercations and the police get involved, your probation will be revoked and you spend the rest of the probation time in prison. The domestic violence, I'm going to waive your probation fees from now until the end of April 2023. Understood?
yes, ma'am.
So you don't pay probation fees, but you need to get started on these family violence classes.
Okay,
After April 2023, you will continue to report to probation and start paying probation fees. So you will be on active probation for the rest of the 10 months left on your sentence.
okay,
Okay. Do you have any questions now?
no, ma'am.
All right, that concludes your case. Position one on the add-on is null pros. Position 3 on the add-on is null pros. Position 2 is a plea. That concludes our SAP calendar.
Thank you, Judge.
Thank you.
And Judge, I just wanted to make sure for Mr. Darris or Daryl Paris, they're not bringing Mr. Paris. He'll be a recess.
Oh, sorry. Yes, I completely. The jail, do we have Daryl Paris?
I have to go to 3 North to get him. I'm still over 3 South, so give me an opportunity to make it to 3 North.
Okay, we'll wait on Mr. Daryl Paris. We are going to go into a breakout to complete the competency calendar. So Ms. Grace, can you place me, Mr. Howard, Ms. McCutcheon, and Ms. Follett and Ms. Burgess?
Can I ask one
Yes,
question first? Mr. Howard, do you still need them to appear on Zoom or what? The guys that are on 3 North, the ones that you talk to?
Yes, Ms. Blunt, still need them.
Okay, I'm headed over there now.
Okay.
All right, we can mute 3 South, please. Ms. Grace, please mute, April, mute 3 South. All right, little bit of confusion, but we are going to move on to a competency calendar. Other than Daryl Paris, have we addressed everyone else on the SAP calendar? Do any of the attorneys have anyone who's not been addressed?
No, Judge, and I believe I've sent my paperwork into Ms. Champion.
Yes, you've been very diligent about that. Thank you. Ms. Francis and other attorneys, if you have any documents, null pros, dismissals, proposed bond modifications, plea disposition sheets, please send that to April Champion as soon as you can. Thank you. Okay, Ms. Grace, we are ready to zoom into a breakout room.
Judge, I have one case on the competency.
Yeah, and I'll address that first. Which one was that again? I know I should know.
Christopher Harris.
Okay, got it. Position 7. I have Mr. Dennis Murphy in the courtroom to address a case on the competency. All right, as soon as we're in Zoom, we can start. Or can I just go back to the same breakout room? I don't know. I don't have that option. Okay.
So yeah, Judge, those football leagues are not nonprofit, meaning they don't do charity work.
Okay, thank you. Thank you for letting me know.
They're listed as a nonprofit, but they don't do charity work.
So she don't have to be. Hello? The judge and some of the assistant solicitors went into a breakout room.
I'm so sorry. This is 5 minutes. Thank you. All right, folks, we've got one more. Do we have one more plea? Daryl Paris?
Hold on, Judge, I'm going into the zone now. I got tired of waiting in the zone because I didn't want anything to happen to me.
All right. Miss Lori Thornton, you can unmute, please. Okay. Miss Thornton, hello. Good to see you again. I don't have don't have very good news about Bennett. He's not being compliant. He's not listening to his attorney, and I cannot release him to Cherokee until he complies with certain things. So there are opportunities for him to get services, but it's been difficult. And Attorney Derek Howard's been working very, very hard.
I know he has. Yes.
But we are faced with some resistance from him.
I understand.
So Mr. Howard is going to check with Cherokee County as to what information he can get. And we're going to see the case again on November 3rd. And hopefully we have a better idea of what situation is Bennett going to enter when he goes to Cherokee County. Because I just need some assurances before I release him.
Oh, I thank you, Judge. I thank you so much.
I apologize, but I know it's been a long, hard road for you. And I feel for you, Ms. Thornton, but I also have to look at the big picture as well.
Of course.
All right.
Thank you so much.
We are monitoring the case. I've been, every time I get this case, I know exactly what you are going through, what your family's going through. And I'm trying to make the best possible decision. But with the resistance and with lack of information from what Cherokee County can offer him, I cannot release him today.
I thank you, Judge, for everything.
All right.
I know it's an impossible situation.
It will get better. I just have to be optimistic. Okay?
Yes. Thank you. You're in my prayers.
Thank you. Have a good day, Ms. Thornton. Take care.
You too.
Daryl Paris, officer.
Position number 16, he's ready, Judge.
All right, thank you. We have Mr. Daryl Paris, position 16, represented by Catrice Helen. This is going to be a negotiated plea, is that correct?
That's correct, Judge.
All right, I can see Mr. Daryl Paris. Mr. Paris, this is Judge Lal. Can you see and hear me? You need to say something. Can you see and hear me? Officer, is that the only way I can address Mr. Paris?
Yes, ma'am, because I'm on the mental health zone floor and I'm the only officer on the floor. I would not be pulling him out for my safety.
Judge, can we just reset him to next Thursday? The October the 27th.
Officer, we're gonna, please let him know that his case is reset to October 27th, and we have to have him removed and placed in a courtroom to address this plea. We cannot address him this way. I can't hear him.
Because he's not saying anything. That's why you can't hear him. He's just standing here. He won't even respond.
Okay. Just tell him next Thursday. Miss Helen, once you speak to Mr. Paris next time for this plea, if you want to submit a plea in absentia form with his permission, consent for a plea in absentia, I'm very open to that idea.
Understood, Judge.
Okay. Thank you. Do you have any other cases to address?
I don't believe so, Judge.
The competent here, Mr. Fennell in zone 300, so I'm headed to zone 300.
Fennell?
Yes, on the competence hearing.
Oh, no, we don't need it. It was waived appearance and we're going to reset that case. Give me a moment. Sorry. Mr. Howard will let him know that his case is he's gonna get a release order. And Mr. Howard will let him know. And he's gonna be released on October 26th under certain conditions.
Okay.
All right, officer, thank you. All right, Mr. Howard, any attorneys, I'm going to close this, adjourn this proceeding. Anything else to address?
No, Judge.
All right. All right, everyone, we managed to pull through this calendar. Thank you. All right, everyone have a good week. Bye-bye.
Thank you, Judge.
Good day.
Thank you, Judge.